Good morning and welcome to the District of Columbia Court of Appeals. We have three matters set before us this morning. The first is Friends of McMillan Park versus DC Zoning Commission and DC for Reasonable Development et al. Versus DC Zoning Commission. Are you ready to proceed? And Ms. Forrester, could you let me know if and how you plan to divide your time?
Thank you and good morning, Your Honors. I will be taking 9 minutes for Friends of McMillan Park. DC for Reasonable Development will be taking 4 minutes, and we would both together share the 2 minutes of rebuttal.
All right, thank you.
Thank you. And I will be addressing the first two issues that this court remanded to the Zoning Commission regarding the consistency with a comprehensive plan. And Mr. Teresa will be addressing the remaining remand issues.
What about the issue regarding the change in the zoning of Plot 1?
And I will be addressing as well the rationales that the Zoning Commission provided for not reaching those remand issues, which I will address second. But I would like to start, if it's okay with the court, with the actual remand issues. And the first issue was the core instruction from this court that the Zoning Commission explained why high-density zoning is necessary in order to advance other policies in the comprehensive plan. And their rationale fails for two reasons, we believe. The first reason is that there's no factual data, no financial pro formas or other information that supports the conclusion that the applicants offered for why high-density zoning is the only way, and the high-density development was the only way to advance these policies. And that's a key difference between this case and the Berry Farms case. And in the Berry Farms case, this court made clear that to justify exceeding the recommended densities, in that case number of units recommended by the comprehensive plan, and I'm quoting that case, the record must contain a sufficient factual basis to support the need for additional units.
Ms. Forrester, can I ask just for clarification, when you talk about exceeding the recommended density, if we're talking about Plot 1, the plot where the medical facility offices was to be placed, as it was originally zoned as a C3C, with a C3C designation, that was for high density. And so when you talk about the recommended density, are you talking about that original designation as opposed to the redesignation of it as a medium density?
I think our argument applies to both. To both, because the building itself, whether you call this zone district medium or high density, and by the way, we have argued that the CR zone district is neither medium nor high. It includes
You're
both.
Talking
but
about for the overall PUD, not
right.
just for that one aspect
or
of
for
it.
or for that one parcel. But that it's the building itself that we're looking at, and the building hasn't appreciably changed. It's still it's been reduced 2 feet. It's 113 feet, but that height is inconsistent with either a medium or a moderate density commercial designation. So our arguments apply whether you rezone it to CR or not.
I have some questions, and I'm going to ask opposing counsel the same question, but I'm a little puzzled by the redesignation from C3C high density to CR medium density. Mm-hmm. And I wonder whether that redesignation to a CR means that what was designated as commercial space for medical facilities could now be a mixed use of residential and commercial. And if it's redesignation to a lower density CR means that it could be mixed use and less dense, mm-hmm. if I could use. Isn't that helpful to the concerns raised by
I don't, and I'll try to answer your question.
Does my question make sense here?
A mixed-use zone can and this is a commercial residential mixed-use zone, but any commercial zone can include residential uses because those are as long as it's within the recommended density. So changing the zone district on parcel 1 to CR, as far as we're concerned, doesn't change anything. It can still be a completely commercial building, and it is a completely commercial building, and the densities in that building, the floor to area ratio, exceed that of a moderate density commercial building, which is, you know, much lower under the PUD regulations. And the height, of course, well exceeds what is recommended density for a moderate zone district or a medium zone district.
So one thing you just said, that you said the height exceeds the recommended density, and I have a little trouble following the connection between height and density.
I'm sorry. I meant height. The height exceeds, you were correct. The height exceeds the recommended height for a medium or moderate density zone district.
By the 2 feet?
Actually, the maximum height for a PUD in what would be considered a medium density zone district is 90 feet. So the fact that the CR zone district allows heights of up to 110 feet, including this bump up that they get in a PUD to 115 feet, doesn't make it a medium density height or a moderate density height. It just, because a mixed use zone, the CR zone, is permitted for both high and medium density uses. So
I'm not sure I understood what you just said. You said the maximum permitted height for a building in a PUD in what you would call to a medium density zone is 90 feet.
That's right, and that would be a
including the 20 feet? Is that including the 20 feet and the 5% and all that, or
yes, it includes the bump up that the PUD gets you, and that would be at like a C2A or C2B zone district.
When you identify, when you're to the extent you are saying that based on a view about what kinds of zones or what kind of densities, are you looking to the discussion of the relationship between zones and densities in the provisions relating to the future land use management plan, or are you using? I mean, where are you looking to in the regs to identify certain zones as medium density zones?
So I'm looking to both the regulations and the framework element of the comprehensive plan. So if you look at the PUD regulations, and you specifically look at 2405.1, which concerns heights, you'll see that the zone district.
Right, I'm with you on that. That just doesn't characterize the zones as medium or high density. So if you're trying to characterize zones in those terms, you need to look at provisions other than that one, I think.
Right, and then you go back to section 105, which is where they characterize these zone districts as medium bulk. So the zone districts that are characterized as medium bulk are C2B, C2C, and the zone district that's characterized as a moderate density zone district would be C2A, and that refers you back to section 105 of the zoning regulations. Can I ask you just,
sometimes in some of those provisions, the word medium or moderate is modified by the word density, and other times the word bulk is used. Those seem like they're potentially different but related concepts. Is there any pattern or logic to that you're aware of, or do you view them as interchangeable, or what's your view about how to understand that?
I do not know. I do not understand the difference. But I do know that the medium, what's designated as medium bulk, would correspond, in my view, when you put it together with the framework element with a medium density. And sometimes they use moderate density, and sometimes they use medium density, and sometimes they use medium bulk, and I honestly don't understand.
You just referenced several different provisions, but I didn't hear you, or if I did, I missed you referencing CR in the regs.
And the CR zone district is a unique zone district, and this is what we have pointed out in our plan. If you go to the framework element of the plan, you will see that the medium, the CR, which is mixed-use zone district, is not specifically denoted in the framework element as either medium or high density. And that's because this zone district clearly permits heights that would be considered, you know, a high density height. 110 feet is out of scale with the zone districts that are particularly designated within the zoning regulations as medium density, and certainly out of scale with the zone districts that are characterized as moderate density commercial.
I'm sorry, so the CR designation carries with it no indication of density? Is that what you're saying? It just refers to mixed use?
That's correct, and if you refer specifically over to 225 point, let me get that, 225.19 is a good provision that talks about the mixed-use categories, and that says the general density and intensity of development within a given mixed-use area is determined by the specific mix of uses shown. If the desired outcome is to emphasize one use over another, the future land use map may denote the dominant use by showing it a slightly higher density than the other use in the mix. The comp plan elements may also provide detail on the specific mix of uses envisioned. So
That's what the commission did here, right? They said, now that everything is kind of CR, we can kind of throw it all in, all the heights and all the FARs and everything. And when we look at it overall, we think the numbers come in under. Was that the approach that they used, kind of a throw it all into one pot and mix it up and we're gonna come out with an average?
it is in part, but of course they recognize that this court in Friends of McMillan Park 1 accepted that that was appropriate for determining whether the overall PUD was consistent with the densities and heights recommended, well, densities recommended by the comprehensive plan. And in fact, they found that at 130 feet, the medical building overall was consistent with those densities. But this court instructions in Friends of McMillan Park 1 specifically said, yes, but you still need to explain on parcel 1 why this high-density use is necessary in order to advance other policies in the comprehensive plan.
Getting back to your initial point, we've spent a while talking about whether the commission reasonably treated this building as non-high density, considered in the appropriate framework. But the commission had an alternative line of thinking, which was, well, even if it's high density, it's still okay, it's outweighed by other considerations. And you started by saying that in your view, the evidence the commission relied upon for the idea that really the only way to finance a project that advances very important values is to have a building that's this intense a use. And your view is that evidence was unduly conclusory?
That's correct.
And what do you think is required? I mean, do you think accountants and spreadsheets and profit margins are the kind of underlying documents that are necessary?
Well, for a start, yes, because that was the data that this court relied on in the Berry Farms case. They didn't just simply rest on what we have here, which is a conclusory assertion that high-density medical facilities are needed. And the lack of data, financial data and pro formas that was in that case and was not here is particularly problematic when you consider that this project was sole sourced to Vision McMillan Partners, and so it was never subject to the real world of competitive bidding, where there would have been other options that have been presented. And in fact, we did provide a letter for the record from a local, reputable local developer who indicated that had this project been competitively bid, they would have proposed a project, presumably financially viable one, that included less dense facilities.
Well, you say presumably financially viable. Did that letter contain the financials that would allow you to, in your view, a non-conclusory way, conclude that it would have been financially viable, or was it at a similar level of generality as the evidence that you're contesting?
A similar level of generality, yes. So, yes.
I was going to say, in FOMP versus the mayor's agent and the DC Historic Preservation Board, a related case, we spent a lot of time at oral argument talking about, or not a lot of time, we spent some time exploring with both parties the viability of the planned use for parcel 1 with the medical facility. And if my recollection is correct, the representations were that given the proximity of the Washington Hospital and Children's Hospital centers and the absence of anything else in the immediate area, and I'm paraphrasing, that was the best use to provide some synergy and to attract the kind of commercial space that could really benefit the area in light of the other medical facilities so close by.
In 2009, that is correct, which was immediately after the Great Recession of 2008, where the housing market had collapsed. And so the developer, and we've shown this in the record, said this is the only possible, economic engine that we can identify in this recessionary economy. Fast forward 10 years later, the housing market is booming. Condos in this area are selling for $500,000. And so it simply begs the question, today, why, when you are proposing a high-density speculative medical building, which even today lacks a tenant, they still have not found a tenant for this building, why are you not considering adding more medium-density residential development, particularly in lieu of the townhomes? Nothing in the FLUM calls for low-density residential development. If you swap the townhomes or some of the townhomes with more medium-density residential development, it seems quite obvious that you could have more room for open space and more affordable housing.
Would you agree that in assessing whether the evidence provided by the developer was unduly conclusory or instead was reasonably sufficient, it's germane the amount and character of any countervailing evidence that was introduced?
I'm sorry, I didn't quite understand.
Yeah, I'm just asking, in trying to assess this question of whether the developer's evidence on this point was adequate to permit the board reasonably to make the finding that it made, or whether it was unduly conclusory, do you think that it's part of our inquiry that's relevant in assessing that question to consider the extent to which any countervailing evidence was introduced, and if so, what the nature of that countervailing evidence was with respect to how concrete or specific it was?
It would have been relevant if the applicants had submitted any financial data to support their very general claim that high-density medical facilities, a spec office building, medical building, is necessary in order to advance comprehensive plan goals. But with that, it's simply a failure of their burden of proof. In Berry Farms, they did provide that.
And other than, obviously, a holding that certain evidence is sufficient doesn't mean that evidence that isn't as good as that is insufficient. It doesn't really tell you the answer to that question in and of itself. Are there any other cases you would point to that would support a conclusion that before the Zoning Commission can reach a reasonable finding on a disputed question that has economic aspects, it requires underlying financial documents rather than testimony?
I can't think of one as on point as the Berry Farms case, but I will say, just simply as to the burden of proof, it is never the opposing party's burden of proof to provide data that counteracts general conclusions, and that was what happened with the environmental impact issue. If you recall, the Zoning Commission said, you, the opponents, haven't proven adverse environmental impacts when the applicant had presented no evidence on environmental impacts, and in FOMP 1 you remanded, saying it's their burden of proof. The Zoning Commission does have to decide.
Well, as I recall, we said something slightly different, which was, it seems like it might be their burden of proof, so either you should hold them to their burden of proof or provide some kind of an explanation about why that isn't their burden of proof. So it was slightly different.
That's slightly different. Thank you.
All right, Ms. Forrester, I know you wanted to hit a couple of other issues, if you could do so, so that we can give Mr. Teresa an opportunity.
Yes, thank you. I do want to very quickly hit the reason why the last-minute adoption of the CR zone district after the close of the public hearing is unlawful. Number one, it's an APA violation, and the suggestion that this is just a technical legal correction is incorrect, because the healthcare facility in a CR zone district is not a matter of right. There are very specific factual findings that must be made in order to approve a healthcare facility.
Can I ask a question, though, as I understood the Commission's rationale here, when when the ceiling heights for the healthcare building were adjusted to a lower height, that seems to be what prompted them to consider revising the designation from C3C to CR, at least as they reason. Doesn't the lower ceiling height and a CR designation with moderate density as opposed to the C3C higher density, that seems to be part of what you've advocated for. Can you tell me, I guess explain why that is troublesome to you?
Well, for a couple of reasons. One is that we've never supported any high-density buildings on this site, none, whether they're in a CR zone district or whether they're in a, C3C zone district.
But now you have the height of, one of the concerns has been the height of this building. And the height is now lower with the new designation. Doesn't that help in terms of what you've advocated?
It does not, because, a 2-foot reduction in this height doesn't make, it doesn't make a difference. And keep in mind that a medium density height would be 90 feet, okay? And which is not appropriate for this building because it's entirely commercial and should be moderate density, which would be more than 5 stories. So the reduction in height is inexplicable for 2 reasons. It doesn't matter for 2 reasons. One, 113 feet is way above medium, way above moderate. 2, the reduction in height, I mean, it doesn't even justify this last-minute adoption of the CR district, because when the building was 115 feet, which is at the beginning of the remand proceedings, nobody suggested that the zone district should be changed to CR.
You had said, I thought you were raising a related point at first, which was the view that's also in your brief, that once you conceptualize this as a CR zone, additional zoning regulations come into play and additional requirements are present. Those weren't met, and that's a prejudicial consequence of the shift. And the question I had about that is, I thought there were provisions in the plan unit development, the government plan unit developments, that say that the commission can approve special uses without going through the BZA process and without making the findings that are required. So I was a little unsure about whether this line of thought works or doesn't work. Do you know the provision I'm talking about?
I do, and I can direct you to it very specifically.
So I think 2405.7 and 8 are the 2 provisions I had in mind.
And it does give the commission authority to approve special exception uses. It doesn't say that it doesn't need to make the findings.
Well, 2405.8 says approval of the board, the BZA, is not required, and
yes,
the commission shall not be required to apply the special exception standards normally applied by the board.
And our response simply to this authority is that it needs to be explicitly exercised. And during a public hearing. So if the applicant is asking the commission to exercise its authority.
Was this an objection that was brought to the attention of the zoning commission, that these provisions and the point you're making now, I know your view is that there was a less than fulsome opportunity to respond to this change plan, but there was some opportunity to respond in a written response, I thought, by Friends of McMillan Park, or am I misrecollecting?
There was a brief written response, but that doesn't, the fact that the applicant, after the record had closed, as opposed to in the beginning of the remand proceeding, suddenly proposed this new zone district, didn't even mention special exceptions, didn't even suggest that they exercise its special exception authority, and the fact that the zoning, that they mentioned it at the last minute, doesn't, I mean, there was a 1-week response period, and we responded, and we felt that the CR zone district didn't solve any of the problems, and we said that, but the zoning commission just adopted it. I mean, that was just kind of a shock because, you know, had this been introduced at the beginning of the hearing and had applicants said, we want to see our zone district, we think that's appropriate for this height of the building, which it might have been, and we want you to exercise your special exception authority to approve a healthcare use, which would include requiring a detailed plan about the healthcare uses, and and would require a description of the need for
Well,
the uses.
you say that, but it would require that only if the special exception provisions were applicable, and these provisions seem to say that they wouldn't be. And so they wouldn't be required if the zoning commission in approving a plan unit development chose not to enforce them.
If the zoning commission had chosen to exercise this authority, it should have done that so explicitly, and it's just sort of a
But you
fundamental.
agree that it could, there's no legal impediment to its having done so, and thus
No.
what you were saying was required, might or might not be required, depending on how the zoning commission chose to exercise its authority.
That's correct, but one would assume that the zoning commission, acting responsibly, would have said, we understand that these provisions about the healthcare facilities requiring a specific need are present and requiring a detailed plan, and we feel that the record supports that, and so that's why we are, exercising this authority. But interestingly enough, throughout the zoning hearing, the remand hearing, applicants were exceedingly vague about what healthcare uses were going to be required. They said, well, we think it probably might involve diagnostic and clinical outpatient procedures that require a licensure from the Department of Health. We'll take care of that later. And that, I believe, is very antithetical to what this court requires, which is at the time of a decision that the agency should grapple with the issues that are put before it at that time.
All right, Ms. Forster, let's get Mr. Teresa up and give him an opportunity to make his argument. Thank you.
May it please the court, my name is Aristotle Teresa. I represent DC for Reasonable Development. And I'm going to be addressing primarily the remand issues of the weighing of the adverse impacts surrounding displacement, environment, and traffic, and more specifically, 4 questions in general. Whether the Zoning Commission failed to make a probative inquiry into the facts regarding issues of displacement, whether the Zoning Commission made a fatal error in calculating the affordability proffered for the project, whether the Zoning Commission failed to consider active policy documents germane to the site, and whether the Zoning Commission failed to make conclusions of law that flow rationally from the facts as regards environmental and traffic impacts. As to the first question about the adequacy of the displacement study, the developer or DHCD, well, actually the developer presented a study that only referenced demographic data in Boston, and they applied it to Washington, D.C., when Title 11, Section 2403.8 says that when you do an assessment of a PUD project, it has to be applied to the specific site surrounding the area. And that's backed up by case law and Capitol Hill Restoration, which says that when you assess a PUD project, that the weighing shouldn't be done.
Just look at 2403.8.
Yes.
The language that I think you're referring to is that the commission should weigh pros and cons, roughly speaking, according to the specific circumstances of the case.
Right.
And you're taking from that the idea that the commission can't reasonably rely on studies or empirical information that is that was based on information arising from a location other than the location of the planned unit development. That seems like that'd be a very tough doctrine to apply.
Well, as I was saying, in Capitol Hill Restoration versus the Zoning Commission.
Well, can I ask first, is that,
okay.
Is that the standard you are asking us to adopt, that if the commission is considering evidence that relates to its balancing under this provision, it can only consider empirical information that relates to the site of the PUD?
Well, I think that it would be on a case-by-case basis, and it's on the court to determine whether or not there's been a probative inquiry into the facts. And so what we are arguing in this case specifically is that there was not a probative inquiry into the facts. and
But
that.
I guess I'm right now a little unsure about the extent to which you think the location of a study bears on, I mean, some of the environmental effects that you rely on relate to global warming and climate studies that I assume are, not focused on McMillan Park. And it just seems, I can understand the idea that it's potentially relevant if a study is in a place that's very different or it's temporarily distant, that its significance gets less strong. But I took you, at least originally, to be saying, to be arguing something a little more than that, that really the evidence here is just not the right character. It can't come from Boston. It's got to come from here.
Given the facts of this case, which addresses displacement, a study like what was conducted in Boston, where they actually delve into the demographic data of the surrounding area, would be appropriate if they had actually done that for the McMillan Park area, and they did not do that. And so for this case, what we are arguing is that if you're going to do a study on displacement, which is very different from the environment, which kind of affects anyone, and we're talking about displacement that is potentially caused by a specific project, that the study would have to include the demographic data of the surrounding area.
So if a group of people who are opposing a development said, we're very concerned about gentrification and displacement, and we can show, based on what actually happened in a bunch of other planned unit developments that are comparable in other parts of the city, that there's been a lot of gentrification, you would say the commission's response would have to be, sorry, that can't be the right kind of evidence for us to consider because it's not about McMillan Park. Or unless you have also added some additional study about McMillan Park, we're just going to set aside your information as not germane to our inquiry.
Well, again, I don't think our argument is we don't want to put forward that our argument is this is what must be done. Only that what was required was not done. So there was not a probative inquiry in this case, given the specific facts of this case.
What, for example, why you think that the study, displacement study, looking at a area in or around Boston was not relevant here? Were the characteristics of that other development and the circumstances so drastically different? Or is it just that it was not here on the grounds of?
Well, for one,
McMillan
DC
Park?
has height limits, which is very different from a city like Boston. In the Boston study, they actually studied the demographics. And so whatever conclusions they raised in the Boston study just are not relevant to this place. Now, if they had done a study about other neighborhoods in Washington, D.C., maybe looking at the facts of the case, that would be relevant, more relevant than just putting a study from Boston here. And again, there's case law on capital.
Did the Boston study look at an area that had previously not been developed, that was newly slated for redevelopment, or did it look at an existing area where housing was going to be removed and a new development replacing it?
I have to look into the record for that.
What was the commission's reasoning on this displacement issue? I thought it had to do with a recognition, yes, prices are going up in the area, there is an issue, but it really hasn't so much to do with the development, it has to do with the influx of young people
Correct.
into the District of Columbia. And that's really the economic, it's that demographic factor that's really driving the increase in values that is leading to displacement. Was that not their reasoning here?
Correct. The zoning commission did find that there is gentrification happening and that it's just kind of a broad issue, and therefore there's that's just kind of what it's going to be. And that sort of bleeds into our next issue of whether or not the—
I'm just not understanding how the Boston study, what it has, how that fits into the stated rationale or the reasoning that the commission had in dealing with this issue.
Well, the Boston study was weighed, and they said that ultimately that it would relieve price pressures, I believe, the additional housing. And so that was from the Boston study.
Can you talk a little bit about the environmental issues and why you think they weren't appropriately addressed by the commission's remand order?
Well, there are two issues primarily. One of the issues has to do with the Climate Ready DC active policy document for the site, which says that public institutions like a hospital or PUD shouldn't be built on flood zones. And this one was built on a flood zone, and that in order, when that happens, that they should complete an adaptation checklist. And that was not done. That was not provided in the record. And also, when it comes to the traffic, the zoning commission never made findings on the increased amount of trips, on the actual increase in vehicular trips to the area, which is going to be upwards of 31,000 cars. And so,
Can I ask you a question about that, a procedural question about the traffic part of it? I take your opponents to argue that traffic really should be behind us. It was really sorted out by the decision in FOMP 1, if we can call it that for short, because there is a part of the opinion in FOMP 1 that says, well, there was a challenge to a lot of the explanations with respect to a number of comprehensive plan policies that the commission didn't adequately address, and the court sends back a bunch of topics. But there's language that says, except with respect to traffic. And your opponents argue that that was an approval, really, of the adequacy of the analysis in FOMP 1 of traffic. And so coming back and really relitigating traffic is too late. What's your response to that?
well, our view of this was that the decision was completely vacated, and that whatever was raised at the zoning commission was fair game, and if they wanted to raise a defense of this issue already being litigated, then they waived that by not raising it at the zoning commission.
On the first part of what you were saying, you're not suggesting that by remanding the case, the court in FOMP 1 reopened every issue, even the issues that it decided. Like, do you think on remand you could have argued to the commission that the language in the McMillan Park provisions that refer to medium and moderate density were just flat out binding? It was something the court concluded contrary to your argument in FOMP 1. I mean, you would agree that whatever was decided by the court in FOMP 1 was not open on remand to the commission thereafter.
Right, and there was...
So then I think the question remains, do you think the court in FOMP 1 actually decided, look, we're done with traffic, there's an adequate explanation from the commission on traffic, so, that's, check that box, that's done. Now, remand on other matters, or you don't read the court's opinion that way?
Well, I don't read it that way because there was the outstanding issue of the weighing of adverse impacts as relates to the environment. And as much as traffic impacts the environment, then that was still an outstanding issue, particularly as regards to increased trips and particulate matter and pollution caused by the traffic.
Is there anything else, Mr. Aristotle?
I just would like to add that when it came to the actual weighing of the benefits versus the detrimental impacts of the project, that was erroneous because they made a finding of fact that there was 20% gross floor area affordability, and there's really only 15% gross floor area affordability. And so even if we were to credit...
Can you remind me,
Yes.
I thought part of the dispute was less about calculating numbers and more about what your measure should be, whether the better measure is number of units or square footage. is all of the difference between, I think you just said 20 and 15, is all of that attributable to your view, to using, are people using the same units of measurement for those two numbers, or are you really in part discussing the question of which of the two units of measurement is a better unit?
Well, the remand order specifies that it should be 20% gross floor area, and they didn't do that at the zoning commission. They only provided 15% gross floor area. And
so the remand order in FOMP 1 directed the commission to do something about
yes, it did.
Square footage of affordable housing?
It did. It did in the FOMP 1 remand order.
Maybe when you get up on rebuttal, you could
Okay.
point me
Okay.
specifically to where that was, because I'd be interested in getting my
Okay.
attention directed to that.
Yes.
Thank you.
All right.
All right. Thank you.
Thank you. And we'll give you and Ms. Förster an opportunity for rebuttal after we hear from opposing counsel.
Good morning, Your Honor, and may it please the Court. Caroline Van Zyl for Intervenor Deputy Mayor for Planning and Economic Development. We plan to split our time with co-intervenor evenly at 7.5 minutes apiece.
Right, thank you.
After remand from this court, the Zoning Commission held 4 nights of hearings on the issues that the court identified in Friends of McMillan Park 1, including testimony from 25 public witnesses, 50 written submissions, representatives from at least 5 DC agencies, and 15 witnesses from the parties. Thereafter, the Commission issued a 96-page order approving the PUD and the map amendment that included 249 findings of fact keyed to the questions this court identified in its original opinion. The order comprehensively addressed each material issue, was supported by substantial evidence, and its legal conclusions flowed rationally from those findings of fact. As such, it should be affirmed. Turning to a point...
We spent a lot of time asking Ms. Förster about the Commission's sort of sua sponte decision at the request of the developers to change the zoning designation, which was not something that was directed on remand by FOMP 1, and it's puzzling. Could you talk about that for a little bit? Why was that done, and what advantages does the CR designation or the change from C3C to CR designation provide the developers? Why did the developers request it at this juncture when that really wasn't anything that was required or directed by the remand order?
Of course, Your Honor. Well, I do think that the determination to remap this Parcel 1 to a CR zone was well within the scope of the remand. Essentially, this court asked the Commission and the parties on remand to find some sort of solution to this high-density issue, either by explaining, which it did, why a high-density use on the site might be reconcilable with the comprehensive plan, or, you know, given that the remand allowed the Commission to change its conclusion entirely,
Well,
I don't think any...
Does the redesignation to CR reduce the density allowance?
Well, I think that the Commission reasonably found that this building can be construed as a medium-density development once it is in the CR zone. And I understand why that might be a little bit counterintuitive, but it has to do with how the regulations and the framework element define what is medium density. Medium density is defined by reference to the uses, the location, the number of stories, it's up to 8 stories, and then by reference to the zone.
Why aren't they defined also by height, in the sense that, I mean, again, it depends what you mean by defined, but if you look at the various designations of zones and characterizations of them as medium, moderate, or high, or low, you can get a sense of what kinds of heights are permissible in what kinds of zones. And so one way of asking the question is there any place in any of the zoning regs where a zone that is referred to as medium or moderate density permits a building of this height?
Well, Your Honor, turning to the text of the relevant framework element, to be sure, it does include zones C2B, C2C, C3A, and C3B, which would permit in a PUD a maximum of 90 feet in height. But it also explicitly says, so it doesn't name sort of height in terms of number of feet in the definition. It goes by stories, which is 8, and this complies in that respect. And in terms of
Right, but
cross-references,
I understand that idea, but do you agree, and again, leave aside permitted plan unit developments, but just anywhere in the zoning regs where you are looking and there are descriptions of what kind of zones are medium or moderate or low or high, and then places where you can see the building heights that are permissible generally in various kinds of zones. What's the highest building height, leaving aside permitted plan unit development provisions, that is permissible in a zone that is characterized anywhere as medium or moderate?
so in terms of the name zone in the framework element, it is 90 feet. But I would note that the framework element says other districts may apply.
Yeah, well,
And given that that language is broad and flexible, and given that the expert agency, the zoning commission here, interpreted that language to say, well, a CR zone might fit, it is another district that might apply to a medium density zone, I think that that determination is accorded deference, generally speaking,
Well,
by
but
this
why
court.
change the zoning designation to a CR, moderate density, from the C3C, which was high density, and then give a variance to increase the height allowance, which was already allowed under the C3C zoning?
I understand, Your Honor. And in many ways, the C3C zone is more favorable to the developers. It's simply more permissive. But I think what you see over the course of this proceeding is both the commission and the parties making every effort to kind of compromise and to, where possible, offer concessions like the concession that perhaps this could be zoned to the CR zone.
Well, does the CR zoning prevent the developer from doing anything at the site that it had initially intended to do when it was zoned as C, or designated as C3C zoning?
So the original PUD proposal was for a 130-foot building, which I don't believe could be built at this point in the CR zone. So there are some limitations there, yes.
Does this, maybe this is a question I should hold for the developer, but does the developer's request to change the designation to CR signal any change or retreat from the developer's plan to put the medical facility office buildings at that site and perhaps use it for other uses, more housing, more?
Again, I would defer to my friend, Mr. Evans, but the PUD that was approved.
This was a big source of the questions at the historic preservation hearing.
Yes.
How locked in is this potential medical tenant?
I think, so in terms of the use for healthcare use, I think that is locked in both by the Zoning Commission order and by the 2014 disposition resolution, which recognized that this would be a parcel for healthcare uses. In terms of the tenants, the record reflects Mr. Weir's testified in ongoing negotiations with at least 2 potential anchor tenants. And at this stage, you're not going to have a lease because it's still, despite all of the proceedings that have happened so far, it's still very early in the development process. Typically, you wouldn't have a lease executed before a PUD has been granted and finalized. We're not even in the stage yet where we can go and get building permits, where we're waiting for this process to play out. And so the fact that there are not currently leases signed, I don't think is problematic, given the very specific testimony from Mr. Weirs, who's, while not qualified as an expert, certainly has tremendous experience in the healthcare sphere, that there are tenants who are interested. There's tremendous value in this parcel as a healthcare use based on its adjacency to the hospital complex across the street, and that there's a tremendous need, right? The testimony in the record was that the district has the second oldest healthcare infrastructure of any major metropolitan area. This area in particular is a designated health professional shortage area, ranked 18 out of 25, 25 being the worst in terms of the need for additional healthcare professionals. And so we are very confident that tenants will come, but at this point, no, there are no leases that are signed.
Now, what about the argument Ms. Verser made about the whole the justification for this more dense, even if it's now 2 feet shorter and under the CR as opposed to the other before, that you need this economic driver, is the term that was used, of a commercial building, a higher density building, to make all these other good things possible as part of the PUD. And they say, well, there really wasn't enough evidence of that.
Your Honor, that's simply not true. There's substantial evidence in the record that this healthcare use, and if we want to call it for the sake of argument, high density, this 113-foot parcel being put to healthcare use was absolutely necessary. And in fact, there was an economic.
This is about the money. This is about whether, in fact, and you just said there is no lease.
Mm-hmm.
And she said, well, there really aren't even enough of the basic documents you would expect to make the economic case that this was necessary for the development as a whole.
Again, Your Honor, that's simply not true. There was a fiscal impact analysis done by Len Bogorad, who is qualified as an expert. It estimated that this project as a whole would bring in $1.2 billion over the next 30 years, and that 67% of that would come from the healthcare building. And that's important because this building takes up only 10% of the footprint of this entire space. So for 10% footprint to be driving 67% of the profits, I mean, that is crucial. And in addition, Adam Weirs testified, and I believe Akash Thakar testified to this in the record as well, that without that economic driver, without that rate of return, it simply wouldn't be possible to do any of the other many beneficial things that are happening on this parcel of land. For example, it has taken millions of dollars to restore the historical structures on this site. It will take millions of dollars to build these parks. Right now, so we say Friends of McMillan Park because that's the name of the organization. I would like to make very clear that this is not currently a park. It is a defunct industrial site which is in substantial danger of collapse. And so to rehabilitate that and open it for to a 17,500 square foot community center, a 6.2 acre park, and on top of that to provide substantial amount of affordable housing, I mean, you really need an economic engine that's going to be very robust.
Your opponents argue that with respect to connecting the intensity of the development there, whether you characterize it as high density or not, to the economic viability of the plan, that the critical testimony is really kind of conclusory testimony from developer witnesses who come in and just say, we really need this, without providing economic chapter and verse about rates of return and what you need to attract the relevant capital. Do you agree that there isn't the kind of testimony? I mean, you gave some specific testimony about one component of the equation, but there are lots of other variables that would be germane to whether it really is financially necessary to have it be, 113 feet or whatever it is instead of 90. Which I think would lose at least one, maybe two floors, I'm not sure. Do you agree that there isn't really detailed financial analysis of the marginal value of smaller buildings that might be either in fact not high density or at least more readily compatible with concepts like medium or moderate density?
That may be true, that there are not there's not the level of detail in terms of spreadsheets that my friends on the other side would like to see, but that's not what's required by the legal standard in a case like this. What's required is substantial evidence, and that substantial evidence can be provided by testimony, by financial reports that don't include, exactly the bottom lines or parameters in the spreadsheets that they would like to see, as long as it's such substantial evidence as the Expert Zoning Commission is willing to accept. To support the premise, then it is sufficient. And that is true to a point you made earlier, Your Honor, even if there is substantial evidence on the other side, right? At that point, even assuming there were enough evidence to go the other way, this court has said in the Watergate East decision and in St. Mary's Episcopal Church and many others that that's the job of the Zoning Commission, to weigh the evidence on each side. And as long as there's substantial evidence that counsels in favor of the conclusion they reached, then that is sufficient.
Well, do you think the commission, imagine a case where this was the issue, there's a level of development with respect to a component of a plan unit development, there's a dispute about whether that would ordinarily be consistent with the comprehensive plan, there's a determination that even if it's not consistent with the comprehensive plan in one respect, the interest in other required or supported policies under the comprehensive plan make that all an appropriate determination. And if the only evidence of kind of necessity, we've got to be this intense, we've got to run up against comprehensive plan provisions about intensity of use because of economic necessity to advance other values. If what happens is a witness who's, let's say, an employee of the intervener comes in and just testifies to that effect and says, look, this is a big development, it's going to cost a lot of money, we're going to need to be this intense in order to achieve these benefits. You would say that's something that the commission can reasonably view as substantial evidence, even if, at least in the absence of countervailing specific contrary information, even though one could arguably view that as conclusory testimony of an interested witness.
I think that's right, Your Honor. I think it's the commission's job in the first instance to weigh the credibility and to make that assessment looking into the eyes, of the employee who is testifying. Now here, obviously, we have much more than that. We have multiple witnesses testifying to the necessity of the 113-foot height of the parcel to take it down to 90 would, to Your Honor's point, take off 2 stories of the building. And I think what you see, particularly in the supplemental response, which is in the joint appendix, is far from conclusory in terms of the very thorough analysis that the developer did in terms of why those 2 floors. The testimony from Mr. Weirs was that we cannot afford to lose another square foot, essentially, of the space and still continue in negotiations with our potential anchor tenants. So what would need to happen is you would either need to cut off the top 2 floors of the building and move them somewhere else, which would very much negatively impact other benefits and asks from the comprehensive plan. It would either take away park space or affordable housing or impact historic preservation, or you'd have to somehow shrink the footprint, condense it even more, and we can't do that because that too would, or rather expand the footprint. You'd have to expand it out. And that's not possible because that too would eat up park space or impact historic preservation if you were trying to expand it south. If you were expanding west, which we also considered, it would impact the view from the Scott statue on the Armed Forces Retirement Home, which nobody wants. If you expand it north, it impacts traffic. If you expand it to the east, you no longer have a 260-foot buffer from the row houses that are across the street. And so really, and I think that gives this court a picture of the level of compromise that has been achieved over the course of negotiations over this particular planned unit development. The fact that we are literally boxed in as far as we can go, trying to meet the needs of every different segment of the community. The council and the ANC, the political representatives here, seem to be quite pleased with the balance of benefits and the compromises that we have achieved, including the 2-foot reduction at the very end there. Sorry.
Can I ask you about the balance of pros and cons? Because am I right in understanding that the zoning commission here said this planned unit development advances every single relevant policy? There's no, on balance, if you look at each one in isolation, check, good. Is that a fair interpretation of what the zoning commission said?
I believe so, Your Honor, at least every single comprehensive plan policy that was raised before the commission. And I don't think that they're required to go fishing for other comprehensive plan policies that were not raised.
Pretty amazing. If that were really true, that would be a pretty amazing achievement by these developers.
And
so
indeed,
you think that, for example, it makes traffic better?
Well, so
I know there was some talk about linkage across it and all, but on balance, you think the commission reasonably thought, yep, this is going to make the traffic in the city better?
Well, on balance, so I would point out that in terms of the comprehensive plan, the traffic policies were not one of the policies that were specifically named. What the commission found was that any adverse traffic impacts could and would be mitigated. And it is true that this site, while it will attract more traffic, no one has any doubt about that, it also opens up cross streets that are currently closed off. There will be 2 major parking garages. There's going to be shuttle service to and from the metro. There are going to be a large number of bike share bikes that are added. And so, if that had been one of the commission's findings, again, I think you could support it, that there are some transportation benefits here, but as to the policies that were named, which deal with affordable housing and the fact that 20% of the units, or about 15% of the gross floor area, is dedicated to affordable housing, including housing for seniors and 22 units in the row houses for larger families. In terms of parks, recreation, and open space, which we've talked about, with nearly 12 acres of this 24-acre site being parks, recreation, and open space. In terms of historic preservation, with all of the above-ground elements being restored.
Do you think it made views, on balance, it's improving the vistas and views in the area?
I think what the comprehensive plan requires is preservation of the important vistas here, and yes, the commission found that those were preserved.
Well, no, do you think it makes them better?
Well, I think you could argue.
It advances the policy of open views and vistas.
I think you could argue yes, in the sense that this site is currently inaccessible, and so there are no views currently from Olmsted Walk. Olmsted Walk currently doesn't exist; it's essentially rubble.
Well, I didn't understand the policy about views to mean views only when you're standing on the planned unit development site. Did you understand that the policy related to views meant views of people who are standing on the site?
I think that is one thing that the commission took into account. It did also look at the views from elsewhere. For example, again, there was testimony on the view from Scott Statue in the Armed Forces Retirement Home. But, again, interpreting the comprehensive plan is a balancing act. As this court has said, the comprehensive plan is full of often conflicting or competing policies. It's this constellation of values. And so what the commission is considering when it's looking at something like vistas is, all right, are we advancing this policy to the greatest extent possible while balancing it against all of the other policies? And here, there's a document in the record that we presented naming over 100 comprehensive plan policies. That's at JA 140, that this planned unit development, we think, is going to further. And while the commission...
I didn't mean to cut you off, but I know we've given you, taken you over your time and given you additional time. Is there anything you want to say briefly as you wrap up so we can give Mr. Evans an opportunity to make his arguments?
I do not think so, Your Honor. I will turn it over to Mr. Evans. Evans, thank you for your time.
Thank you.
Good morning. May it please the court. Philip Evans on behalf of Intervenor Vision Macmillan Partners.
Good morning.
I have quite a detailed outline. It's not as detailed as the zoning commission order, but I think the better thing to do is address some of the questions the court raised today. And first, to Judge Blackburn-Rigsby, the CR zone is a significant compromise by the development team. A C3C would allow 130 feet of height and a commercial FAR of 8.0. When you drop down to a CR, you drop down to 110 feet of a PUD height and a commercial FAR of a 4.0. And you also, as opposing counsel has noted, you subject yourself to review as to whether something is a matter of right or requires review. And one of the issues raised about, does our project require additional review? Depending upon the type of healthcare facility it may become, and it may become is key. Things have advanced since the hearing itself. We have gone beyond no lease to a letter of intent with Children's. That was in the record before the mayor's agent case. So they're making progress. But still, we are years away from knowing what the exact use will be of this medical facility, and when and if it complies with the requirements in the CR zoning as to whether it won't never be a hospital, but the CR zoning talks about hospitals or clinics. If this meets the definition of clinic under the zoning regulations, which is very specific, then the developer will task to go back before the zoning commission and get appropriate review. I don't think, in response to Judge McLeese's question, while the commission has given some acknowledgement about its ability to enforce the BZA regs, that there was not sufficient evidence put forth as to the exact need of the building and what's going to happen.
So that in answer to one of my earlier questions about the change from C3C to CR zoning, are there uses on the property, uses for the property that the developer would no longer be able to pursue as a result of the redesignation to CR zoning?
In the development plan as put forward for the commission, there is no change that they could not do. I think the CR zone restricts to massage parlors, tattoo parlors, things like that. That was never part of the development plan. It's very limited. But what it does make a difference is is there are a number of areas, and most important for this are hospitals and clinics, that you then, instead of being a matter of right, you do have to go back and establish certificate of need and other obligations. And if the development plan as put forward gets there, that will be on the burden of the developer team to go back and get the appropriate approvals, not only from the zoning commission, but from other bodies within the district. And part of the challenge as we talk about the CR zone is looking at the framework elements of the comprehensive plan. One thing is clear, the CR zone is not mentioned in the 4 framework elements that defined low, medium, moderate, and high. And that's why you step down to the part that said that for a large site mixed use, there's no question this 25-acre parcel is a large site in the District of Columbia. And there's no question that the multiple plans put forth for it, mixed use is what the city wants. The city wants everything it can get out of this for its citizens. So the CR zone, and as the Office of Planning said, it's the perfect fit. And it was, by the way, the perfect fit for the other 6 parcels on this site that went forth in the first zoning commission case. And again, so now we have all 7 parcels at CR. Whether you call this medium or high density, the commission has articulated how both apply. I would say it fits within the upper limits of medium, but it could also be at the bottom limits of high. It's not to say it is not a large structure. But this turns to the financial aspect.
But the change in the zoning, and I know I'm harping on this because I may not be clearly understanding, so help me here. That doesn't signal by the developer an intent to decrease the density of any planned use of parcel 1, does it?
At this stage, no. I mean, that signal was made in the first application where the developer really originally went in for a 130-foot building, and through much effort and consternation and pushback by the zoning commission, they dropped it to the 115. The extra 2 feet they found this time made it qualify for the 5% bonus density to allow CR to fit. And also, quite frankly, if you look at the transcripts we provided this court in the appendix, the zoning commission struggled in interpreting this court's direction from FOMP 1 and looking at the regs, how C3C really fit. Because they see C3C as a high density, typically restricted for the downtown area. And they struggled with that. And so, yes, at the end of the day, they looked and said, we have found a way to make this work that's consistent not only with the directives of the framework elements and the general elements of the comprehensive plan, but also the direction provided by the city itself. And what's important when you talk about financial information, they argue that we didn't provide performance. And as Ms. Van Zyl has suggested, there were not granular financial details provided as in a pro forma, which may be required in other proceedings for the BZA, but they're not required here. But there is significant high-level financial data, and it's contained in the LDA and then the council resolution approving this project. And that talks about the $1.2 billion in gross revenues this will generate and the $870 million net to the city. That's what this project is doing, is not only providing a mixed-use development that meets all of the needs of that, but is also an economic driver for the project and for the city as a whole. And that's what had the council adopt this resolution. Remember, the council is the same one who approves the comprehensive plan. And
I had a question about that. So what is there any impact of the legal nature as a result of that council resolution, precisely for the reason you just said?
I think as a panel of this court announced earlier this fall, it's appropriate to look to the council action to determine conformity with the plan. It's not legal in the sense that it's a binding resolution. The comprehensive plan still applies, and the applicant team of the deputy mayor and VMP must satisfy that it complies with that. So it's not binding in any sense, but it is a good reference point. The council has supported this project. They see it as supportive of not only what they can do with those 25 acres, but the money generated from this project will support other needs of the city. And that ties into the question of displacement and gentrification. I take great offense at the suggestion that Mr. Bogerad's report simply relied upon a Boston study. He did employ a Boston study as a definition of gentrification. But look at his testimony, which also provided the record. Mr. Bogerad examined areas of Mount Pleasant, Stronghold, Edgewood, Brightwood. He made specific contacts within the city. He testified to this. He looked at all the impacts around the city. He often also referred to materials that these other side had proposed. His study was well detailed and supported by evidence of the city as the impacts. And when you combine his conclusion with that of DHCD, who the opponents have identified as the expert in this, the important thing to address gentrification, which is a real issue.
What would you say the conclusion of the DHCD was on gentrification?
The issue is that overall, this project will ameliorate the issues of gentrification by providing affordable housing, units and affordable housing.
That's how you
units.
interpret the DHCD letter?
That's one of them. That's one of the conclusions. I mean, it did.
Well, there's a dispute about how to interpret that letter. There's a sentence that says, we're not tearing down any, this is paraphrasing, so feel free to correct me if you feel my paraphrase is unfair, but there's a sentence that seems to be focused on the point that we're not ripping down any existing housing. We're adding housing, so that will be good. It tends to help deal with housing shortages and displacement and the like. We're not, sometimes if you are ripping down something where people live, then there's
That's displacement.
Definitely not having that, and definitely not doing that. But then there's a later sentence, and then the end of that sentence, I think you've interpreted as meaning there's no concern about gentrification overall.
No, I did not mean to convey that, Your Honor.
Okay, well, anyway, the later sentence says, a project like this is intended to benefit, will have, affect property values, can help some people, but can also result in housing affordability pressures, thereby playing a role in residents moving out. So it seemed to me that—
Don't stop there, Your Honor.
Okay, sure.
Read the sentence after. The sentence after is key, that they say, but the district has other plans and programs to deal with those pressures as they arise. And this ties back to the financial benefits of this program.
Right, well, so I mean, if we may see things roughly the same way tentatively if what you think DHCD said is no immediate physical displacement, creating new housing, which is a good thing, but effect on property values can have displacing effects. Really doesn't say there are going to be some of those or there aren't going to be some of those, so kind of agnostic about whether there will be those effects. But we have policies that will allow us to mitigate them, which doesn't mean there isn't going to be gentrification or indirect displacement. It just means we can fix that problem.
The evidence suggests already that
I understand, but I'm just trying to—
gentrification is taking place,
Understood.
absent the development.
Understood. But would you agree that it is a natural effect of rising property values that they can tend to cause— is it a predictable effect that they can tend to cause gentrification-related displacement?
I think it is a fair statement that rising property values have both positive and potentially negative benefits.
And one of the potentially negative ones is people who live there who are no longer able to afford to live there.
Which also drives other areas of this project, which is affordable senior housing. One of the things
Understood.
we see in gentrification is
My main
fixed-income
point
seniors.
of discussion with you is I'm not sure what DHCD says is there will be no gentrification problems. It seems to say there won't be physical displacement. There will be some good gentrification type considerations. There may be some bad ones. Don't really say how big or whether those will exist, but we're confident we can mitigate them. That just seems like a somewhat more complex set of remarks
what we agree upon is that the DHCD report must looked at as a whole because it contains many competing conclusions, but overall it is supportive of this project. And the same overall analysis must apply to the comprehensive plan in support of the Zoning Commission's determination to support this. McMillan is a tough cookie. And in the words of Deputy Mayor Kenner, it was a project of compromise, and nobody is ecstatic about it because you had to give to all parties. It took years. It took over 10 years to get this plan together. It had 6 iterations, 200 community meetings, thousands of submissions. It's a balance, and it is a well-done balance. Half of this site, 49% of this site will be open space and recreation, one of the key needs. It brings senior housing, it brings affordable housing, it does bring some family affordable housing, not the levels that DC for regional development like, but it does bring some. This one project cannot solve all of the housing issues faced by the District of Columbia. And it also provides an economic engine. The driver, as we testified, Mr. Weirs, Deputy Mayor Kenner, as to the importance of what this project, and Mr. Thakar, what this project brings not only to the project as the project, but to the city as a whole. It's been 30 years in the making, and to quote Deputy Mayor Kenner, it's time to let this project move forward. Thank you.
All right, thank you, Mr. Evans. Ms. Firster, we'll give you a couple minutes for rebuttal. Okay.
Really quick, I would like to correct two issues. One of the issues is that the remand order, the 20% GFA, that was from the zoning commission where they specified that, not this court in FOMP 1. And also, the issue of what was in the Boston study. The Boston study was an infrastructure project. And to just continue on that point, opposing counsels raised the issue that gentrification is something that is happening citywide, and that they did address some other neighborhoods in their studies, and we acknowledge that. However, it is the zoning commission's duty to provide for the stability of neighborhoods and also to do a probative inquiry into the facts. And for a project of this size, we argue that that simply was not done. In order to do that, one cannot start with the conclusion, which is that gentrification is happening anyway, and then find statistics to back that. The zoning commission's duty is to do a probative inquiry into the facts. And in order to do that, that would require some sort of demographic data specifically referencing the site and how this project is going to impact those people. This project may have some housing for seniors, but there is no very low income housing in this site. And DHCD has stated that this project will lead to displacement. Any other mitigating policies that they have throughout the city withstanding.
Thank you, Mr. Aristotle.
Thank you.
Or Mr. Teresa, I apologize. I've been calling you by your first name instead of your last name. Thank you. Ms. Forster.
Thank you. I have 4 quick points I want to address. First is the notion that there is any, the kind of financial information that Berry Farms calls for in order to determine that high-density development is necessary to advance the policies.
Before you get into that, what makes you say Berry Farms calls for that kind of information rather than the Berry Farms determine that that kind of information is sufficient?
Relied on. Thank you for that correction. Relied on. And the report, the fiscal information in the record simply relates to the projected fiscal impacts of the office building in terms of tax revenue and employment benefits. But the data that was relied on in Berry Farms was very different from that. That's financial pro formas, talking about the cost of building each unit, the infrastructure cost, and the rate of return for the developer. So that's a very different type of economic data. And as to that second type of economic data, it is not in the record. The second point I'd like to address is Mr. Evans'
but
point.
on that point, Ms. Forster, are you saying that the larger impacts in terms of tax revenues and employment is something that could not be taken into account?
In a different...
And I understand that it's a different impact, but are you saying that only if they can show that they needed this building to make the project itself financially viable, can it be approved? Is that what you're saying is required?
Those tax and employment benefits are very much relevant under the other PUD standards, for sure. But in terms of this court's remand instruction, that this court, that the zoning commission determined whether or not high-density development is economically necessary in order to advance other goals of the comprehensive plan. No.
Of this actual
That's correct.
development.
Yeah, it's
Okay,
not
thank you.
relevant to that core instruction. As to Mr. Evans' point, that regarding the healthcare facility, that well, you know, they can just do it later in terms of getting going back to the zoning commission and getting the kinds of the approval that they need for this type of use.
I thought his point was a little different. That the CR. I thought his point was that the CR designation actually imposes some additional restrictions and requires some additional approvals, which I understood him to be saying was one of the developers' compromises, if you will, because they didn't need those same, to return to the zoning commission for these same reviews or approvals under the C3C zoning. I may have misunderstood.
I
his
did
argument.
hear him say that they plan, and in their brief, in fact, they did say that we plan when all this, negotiating with the anchor tenant is completed and they determine what the specific healthcare uses will be in this facility, that they do plan to go back to all the permitting officials to get the specific
Well,
approvals
but the
that they need.
CR zoning or the CR designation actually requires some of that, where the C3C designation did not require.
Right, so assuming the CR zone district is upheld, they say they plan to go back and do all that, get those kinds of specific approvals.
Well, but they have to. In other words, I don't mean to banter back and forth.
They have
With
to.
this new designation, it actually imposes some additional requirements on them to go back that didn't exist under the C3.
That's correct. And the point that I wanted to make is, and particularly I'd like to refer you to the Committee of 100 decision at 571A second 195, which stands for the proposition that you can't just say, we'll take care of it later. If there's a regulatory requirement that's specifically applicable at the time of the decision, you can't just say, well, we're going to approve it and let the third parties take care of it later. We're going to let them go back to the BZA or to the zoning commission
But
and
I
deal
don't
with
think,
that.
and I'm sorry to keep harping on this, but I'm not sure if that's an accurate characterization of what's happening here with the change in the designation, unless I'm misunderstanding what the regs require under CR.
Well, the regs.
They're not, it's not another, I don't read it as an attempt to delay getting approvals that should be gotten now. I see it as another layer of review as the project moves forward, a layer that's not present under the C3C designation. So it is it's an additional hurdle as opposed to I hear you arguing that it's perhaps an out for the developer, and I see it as an additional regulatory burden.
That's true, and if you remand it to the zoning commission, they would our position is they need to address that now. They cannot our position is you can't approve the CR district and rely on the fact that those new different regulatory requirements that become to the fore in a CR district relating to healthcare facilities will just be dealt with on, some subsequent, when they finish their negotiations and
I have a
make it.
practical question and a legal question to join them together. Your opponents suggest that that's not at all practical, that you wouldn't be able to make those specific findings until you were way further down the road than you would ordinarily be at the time that the commission is approving planned unit development. That's the practical point. Then the legal point is the provisions in the planned unit development process, 2507, and 8, seem to confer upon the zoning commission at least a fair bit of discretionary authority about whether to impose those requirements at all, or if so, when and in what format.
As to the practical issue, I don't think that's relevant. I think that this project has been 10 years in the making. They've managed to secure a lease with Harris Teeter based on the financial strength of the project without a commercial tenant for the healthcare component, and I think they can figure out what kinds of healthcare uses they need to incorporate into this project at the time of the decision. And all I'm saying is the Committee of 100 decision stands for the proposition that now is the time, or on remand is the time for the Zoning Commission to make the decision about whether or not it is okay with the healthcare use in terms of its authority to approve special exception uses. I also want to briefly address the point that was raised about other policies of the comprehensive plan that the commission just kind of said are met, and particularly with respect to this court's specific remand instruction that the commission address the comprehensive policies that call for dispersion, not concentration, of healthcare facilities to underserved areas or medically underserved areas of the city, specifically areas east of the river. And the commission's discounting of that provision is inadequate here. They simply point to introductory language in the element that says that there is a commitment on the part of the district to disperse healthcare facilities to these publicly understated areas. And they translated that into this policy only applies to public health care facilities. But in fact, if you look at 1106.10 and 1106.11, that specifically applies those policies strongly favoring dispersion of healthcare facilities to these underserved areas to private healthcare facilities. And I would also just suggest that this project is getting $80 million in public money, including the development costs for the site preparation, a very deeply discounted land value, and it's including the soft development costs, including up till very recently the cost of my esteemed opposing counsel. So one could argue that this healthcare facility does qualify for that commitment that the comprehensive plan calls for a dispersion of public healthcare facilities. And then just briefly, the 8-story question that was raised by counsel for DEMPED. You know, the FLUM, which specifies that medium density commercial buildings should be generally no more than 8 stories. It says the word general. And a general typical building like most of the other buildings in this plan generally have floor-to-floor stories, heights of about 10 feet. This healthcare building is not the typical building. It has floor-to-floor heights of between 13 and 19 feet each. Hence, it's an 8-story building technically, at least from the northern elevation. I would also note that from the southern elevation reads as 9 stories. But in any case, as Judge McLeese, you pointed out, the idea that generally the buildings are 8 stories does need to be read in conjunction with the specific zoning regulations, which make clear that 90 feet is what a medium density building is.
Well, what I kept reading was that the reason for these higher ceilings had to do with the proposed use as a medical facility.
That's correct.
Right.
That's correct. And I'm just saying that, but generally, and that's what the framework element of the plan refers to, generally, an 8-story building is probably going to have the typical floor-to-floor ceiling heights of 10 stories,
right.
10 feet.
All right.
And just to wrap up, I think what I want to leave you with is the fact that my clients, this community, is not opposed to development on the McMillan site. We never have been. They want the Harris Teeter grocery store, which is under lease now, and they want the swimming pool and the community center and the park, which will be paid for by the District of Columbia, not the developer. What they don't want is the high-density medical building because it serves no identified need in the comprehensive plan or any strategic plan for the city. And they don't want the 31,000 additional cars on North Capitol and the already failing intersection at Michigan Avenue.
Thank you, Ms. Forster. I thank all parties for your briefs and arguments, and the matter is under advisement. Our second case this morning is In re Frederick Schwartz versus, it was In re Frederick Schwartz. All right, I would ask, since we have another case about to proceed, if parties, you're welcome to stay, but if you are leaving, if you could leave quietly, I'd appreciate it. All right, are parties ready to proceed?
Good morning, Your Honors. I would like to reserve 2 minutes for rebuttal.
All right, if you could state your name for the record, please.
May it please the court, my name is Jelani Lowry. I'm here on behalf of the Office of Disciplinary Counsel. Disciplinary Counsel is here today to defend the court's well-established method for determining sanction. We're asking the court to clarify that method and that process for sanction analysis so that it can continue to rely on and defer to the board's recommended sanctions. In countless cases, the court has said that it will consider 6 sanction factors: seriousness of the misconduct, prejudice to the client, whether the conduct involved dishonesty, violations of other disciplinary rules, whether the attorney had a previous disciplinary history, and whether the attorney acknowledges the misconduct.
Well, in this case, I guess part of what is at issue in the exceptions is, as I understand it, is initially when Mr. Schwartz was charged by disciplinary counsel with violation of Rule 1.4, there were no aggravating circumstances identified by disciplinary counsel until after the proceedings and hearing for the hearing committee, even though, as I read the record, all of the factors listed as aggravating factors were known to disciplinary counsel at the time of charging, or at least before the hearing. Is that correct?
That's correct. What the respondent, Mr. Schwartz, is relying on is a statement that was made at the hearing, after the hearing, actually the bifurcated proceeding, and after the first phase of the hearing, the disciplinary counsel said that there were no aggravating factors. It was an inartful statement. What it meant was that there were no additional aggravating factors, and in practice, what happens is that most of the evidence that goes to these aggravating factors, these 6 that I just listed, most of the evidence comes in the first phase of the hearing when we're producing evidence to prove the clear and convincing evidence of the rule violations that we've charged. In this case, when the board reached, after the board found clear and convincing evidence of the 1.4.
Okay, I'm sorry, most of that evidence came in, there were aggravating factors, I think, related to Rule 1.16 that are being raised here. I guess I don't understand why those weren't charged initially.
Well, those were not charged in this case because there's a board rule 6.4, that says that disciplinary counsel cannot charge additional rule violations after an informal admonition has been issued and rejected. So disciplinary counsel could not bring a 1.16D charge, but that does not mean that it could not be, the same facts could not be considered. And if I can get to...
Just to roll back a second, though, that just poses the question of why, in whatever process occurred before the informal admonition was proposed and rejected, this wasn't listed as a rule violation at issue.
Yes, I believe that there was something in the informal admonition about an ACAB proceeding, which is the Attorney-Client Arbitration Board, and I did not issue the informal admonition, but I believe that there was some thought that ACAB might resolve some of these issues, and that if respondent did not comply with that ACAB proceeding, we would reopen that investigation.
Was there an ACAB proceeding?
As far as I know, the ACAB proceeding did not take place.
So there's no order outstanding to which Mr. Schwartz has not complied, requiring him to return any funds back to the client, Mr. Chen, is there?
No, there's not.
In fact, there's been no determination that the fee should have been returned, right? That the $2,000 that were paid.
That's correct.
And has there been a request by Mr. Chen for a return of the initial retainer?
There was a request from Mr. Chen, as far as I recall, and a respondent refused to return the fee. But really, the important thing for disciplinary counsel is the process that is used to arrive at the sanction analysis. And if we can go through that process, I think it'll become clear why the facts can be considered in the sanction analysis, the facts that underlie what the board has called uncharged rule violations can be considered and are considered in other cases for this court. So here the
board, just to be clear though, the board didn't preclude such consideration. It said there might be due process issues that might have to be addressed, but they didn't need to address them as it relates to this case, what they said was, they seemed to say that such circumstances would be considered even if uncharged, but that they would need to be established by clear and convincing evidence.
That's what they said, yes. And disciplinary counsel is arguing that they do not need to be established by clear and convincing evidence. And we have as support, we have the case of N. Ray Waller.
And would you say ever? There's just, so in no circumstance, other than, there are a few places where this court has said clear and convincing evidence is required at the sanction stage. We've identified a few areas. You view them as kind of specific exceptions to an ordinary rule that clear and convincing evidence is not required. But would you say that other than those pre-existing exceptions, disciplinary counsel is not required to show circumstances in aggravation by clear and convincing evidence ever?
Yes,
And just so concretely, if a lawyer is believed by disciplinary counsel to have failed to communicate with a client and then lied to a court about it, and disciplinary counsel at the front end is making a charging decision, and imagine it expressly thinks, I mean, we have the lawyer dead to rights on, whether there was non-communication, but we're not so sure about the lying to the court part. So we'd really rather not have to try to prove that by clear and convincing evidence. So we're not going to charge it. What we're going to do instead is we're going to litigate the question of whether there was lack of communication, which would ordinarily call for a relatively modest sanction, let's say. And then comes the sanction phase. They're going to try to prove by a preponderance that there was this separate rule violation that is a much more, let's say, much more serious conduct, and then try to argue for a quite substantial sanction, far more than what would ordinarily be appropriate for a mere lack of communication. You would say that's all fine. Every aspect of that raises no concern in your mind.
I would say that that's not fine, and that's not what disciplinary counsel would be attempting to do. What we would be attempting to do in that situation.
What principle of process would preclude disciplinary counsel from doing that in your view?
So in your example, a Rule 1.4a violation carries with it a range of sanction.
Where's that? You mean by some regulation or rule, or where is that?
By this court's sanction analysis, this court's case law is on sanction analysis is all in the court's case.
Understood. So is there a case that you would point me to that would say, no matter what the aggravating circumstances are, if the underlying violation is failure to communicate, the highest possible sanction is X? Is there a case that says that, and if so, what's X?
No, it's not. It's not that simple. What it is establishing a range of sanction for comparable, similar misconduct. And so one of the things you look at is what is the rule violation, the 1.4a.
Right, but can you point us to a case where the rule violation charged and found after a hearing before the hearing committee consisted of only a violation of 1.4 communication, failure to communicate adequately with the client, where the sanction was more than an informal admonition?
No, I cannot point to that case, and I don't know that case exists. What we have in our case law and for the court to look at is the informal admonitions that have been issued, and also cases where there have been a 1.4a and a 1.3, for example.
Can I just, so make sure I understand, you were saying that if disciplinary counsel did what I was hypothesizing, that would not be okay. It sounds like what you're saying is it would all be okay, but the effect of it would be limited, because no matter what the other aggravating circumstances are, you think that the board might be limited in the harshness of the sanction that could be imposed. And so disciplinary counsel could do all that, but at the end of the day, it wouldn't be able to persuade the board or this court that a really significant sanction should be warranted, because this court would, and the board would, put a lot of weight on what was the disciplinary violation actually found. And if that's relatively minor, no matter how bad the other aggravating circumstances are, they just wouldn't be able to generate a harsh sentence. Is that how I understand you think things should work?
I believe it's close to what I'm saying. I believe what I'm saying is that there is a range of sanction that is going to be established. Before we apply the 6 sanction factors, a range of sanction is going to be established. And then the 6 sanction factors are going to be used to determine where on that range this specific respondent's misconduct falls. And so the range for the range for a 1.4A violation would be different from the range for a 1.4A and a 8.4C violation.
Fully understand that. But let me just say, again, procedurally, imagine that I'm a respondent who's charged with, who's under an investigation, and then there's a charging document that says I failed to communicate with my client. And then as we're getting ready for the board hearing, it becomes clear that disciplinary counsel intends to also prove that I lied to a judge about it, and they want to use that at the time of sentencing. If I say to the hearing committee, don't let disciplinary counsel proceed in that way. They're clearly trying to, they know that that's a possible charge. They're deciding not to bring it against me for reasons that are completely, there's no good reason for it except that they're trying to get a lighter burden of proof at sanction, even if there's a limited effect that they can get from the benefit of that. You would say that's not a good objection by me. It's fine for disciplinary counsel to proceed that way, and the only issue is going to be what constraints are imposed on what otherwise might be the use of an aggravating factor by the circumstance that disciplinary counsel, the ultimate finding was only for a violation of Rule 1.4A. Is that right? Is that right, or am I missing some aspect of your position?
I don't think that's what I'm saying. What I'm saying is that that would not normally occur. It doesn't normally occur.
My question is about what would normally occur.
And that would be a good argument on the respondent's side. The reason that doesn't occur.
It would be a good objection?
It would be a good objection, yes.
And it would sound in what due process or what principle of law would be at issue?
You would have to consider the sanction under the fourth factor, which is violations of other disciplinary rules. And
I guess I wasn't clear on my question. The hypothesis I have is the respondent is saying way before sanctions, at the time we're getting ready for the hearing, don't allow disciplinary counsel to proceed in this way. They really want to charge me with two things, one that's relatively minor and one that is much more serious. But they're trying to do an end run around their ordinary requirement that they show rule violations by clear and convincing evidence. So either make them charge both, which would be, seems like a problematic remedy, or preclude them from relying on it in sanction, but don't let them do this. Is that a good objection or not a good objection if it's made at that point? What should the hearing committee do? Should the hearing committee say, oh, that's fine, go ahead and do that, disciplinary counsel, we'll sort it all out at sanction, and there'll be some limit on the weight that can be given to that consideration, but this is a fine way to proceed in principle. Is that what they should say, or do you think it would be a good objection and the respondent should get some relief at that point?
At that point, at the hearing, everything that is relevant to the charges that disciplinary counsel is bringing is admitted under our rules. Under our rules of evidence, everything that is relevant to the 1.4A charge comes in. So what respondent would really be arguing is that that's not relevant to the 1.4A charge. But if it is somehow relevant to the 1.4A charge, it should come in. And once it's in the record, it can then be considered as a part of the whole record when you're looking at the 6 sanction factors. But in that case, if disciplinary counsel had clear and convincing evidence, disciplinary counsel would have charged the 8.4C. And that's why you don't see a lot of cases where this number 4, violations of other disciplinary rules, is taken into account.
Point me to a case, in answer to my first question, that were there other cases where the only charged and found violation at the hearing level was a violation of 1.4, where the sanction was greater than informal admonition? Your answer was no, there are no cases like that. Are there cases where the only charge violation, the only violation found by the hearing committee was 1.4, and then aggravating factors came into play afterwards to increase that?
I don't think we have a lot of case law on just one single 1.4A violation. It doesn't come up that often.
So then where does this fit? I guess that's what we're trying to figure out here. You're saying that a 1.4 violation plus aggravating factors that you identified found by a standard less than clear and convincing evidence would be enough to increase the sanction from an informal admonition to public censure?
Yes, and what I'm basing that on is, A, there needs to be a range for the sanction, and I don't think that it's ever been said that a 1.4A violation can only be an informal admonition. So just because We have informal admonitions that have been accepted by respondents who have accepted and acknowledged their misconduct, and those haven't come back as rejected and come up to the court that often. Doesn't mean that the 1.48 range for a violation is limited to an informal admonition, and no matter what aggravating factors exist, you can only get an informal admonition. And so here what we're arguing is that if you look at one case that we didn't cite, which is N. Ray Schlemmer, we didn't cite that in our briefs, but it goes through a good analysis of the difference between an informal admonition and public censure. And in that case, and there was two Schlemmer cases. There's Schlemmer 1, where the court actually remanded to the board, and Schlemmer 2, where the board came back recommending, it had first recommended a public censure, and when it came back, the board recommended a board reprimand.
Can you
but
tell
that
me
is
what
kind
the
of the
difference, what is the operative difference between an informal admonition and a public censure at this time?
Informal admonitions are issued by disciplinary council and published in the Washington Lawyer, I believe, and board reprimands are issued by the board, and the public censure is a more serious sanction that carries with it publishing in the A-Second Reporter. So there are three distinct levels of, those are three distinct levels of discipline, and that's discussed in the Schlemmer cases. And we think that that is.
By the way, could you give a cite to the cases that you're mentioning that were not in your filing?
The first Schlemmer case is A40 A2D 657. And the second.
And that's what year?
That's 2004. Okay. And the second is A70 A-Second 76, and that's 2005. In that case and in the Waller case, the board considered rule violations. Waller we did cite in our brief. The board there considered rule violations that were not charged or proved by clear and convincing evidence under the fourth factor, which is violations of other disciplinary rules, and considered those rule. And in Waller, the board said, it seems like this might have been a conflict of interest as well. And so they're taking that into account and weighing it as they're weighing all of the other factors.
Can I ask you, when we're talking about case law, your opponent, I think, relies on a case of ours called In re Downey, which your opponent, if I'm recalling correctly, suggests reflects by this court some understanding that any fact that's being relied upon to aggravate the otherwise applicable sanction needs to be proven by clear and convincing evidence. And the quote, a quote from that case is, "We are not persuaded that disciplinary counsel proved dishonesty as an aggravating factor by clear and convincing evidence." What do you make of that sentence in Downey?
That sentence was something that the board stated and that disciplinary counsel did not take issue with in that case, so it was not squarely before the court as an issue that disciplinary counsel objected to. And in addition, you mentioned earlier the two separate areas where the court has said clear and convincing evidence is going to be required. That's intentional or reckless misappropriation and also fitness. And we were asking for fitness, I believe, in that case. And so it was something that disciplinary counsel would have to have proved by that higher standard anyway to get the sanction that we were asking for. So we think that that case is distinguishable because it was not something that was before the court directly, and in addition, fitness was at issue.
And what's your global theory about, there's a third area, at least where there's a clear and convincing evidence standard for sanction, which is on the respondent in mitigating evidence. So there's at least a third, dot on the map where clear and convincing evidence has been required by this court. What's your sense of, are those just two unexplained exceptions, or is there some doctrine that certain kinds of aggravating circumstances must be proven by clear and convincing evidence, and what's your understanding of the line between those that do require it and those that don't?
When you say the third area, are you talking about Kersey mitigation? Yes. So we think
part of that is required. There's a component of that poses a burden on the respondent to show something like clear and convincing evidence.
That's correct, and we think that we think that Kersey again is another special circumstance. It's not mitigation of the usual sort that a respondent is going to be introducing, which would not carry those burdens. We think, again, that it's not really, when you're doing the sanction analysis of those 6 factors, the board and the court aren't placing a burden on disciplinary counsel or placing a burden on the respondent. What they're doing is looking at each factor and saying the seriousness of the misconduct. Does that move the needle, looking at all the evidence in the record, does that move the needle towards the harsher end of the sanction or towards the lighter end of the sanction? Prejudice to the client. Is there no prejudice to the client, or is there prejudice to the client? And that would move it in one direction or another.
When
Looking
you
at
say
all
move
those
it,
factors.
are you saying move the burden of proving by clear and convincing evidence versus by preponderance of the evidence? You say moving the needle to one.
What I'm saying is it's not, what I'm saying is that disciplinary counsel's burden of clear and convincing evidence applies to proving the rule violations. And once we've proved our rule violations, the sanction analysis, the sanction factors, is just a weighing of the evidence and deciding where
What's
to go on
troublesome
that
to
range.
me about that argument is that if you go back to the hypothetical that Judge McLeese gave earlier, that allows potentially disciplinary counsel to pick the easiest thing to prove. You know, here, the 1.4 violation, well, this is easy, we'll prove this by clear and convincing evidence. But the real meat of what we're concerned about, you know, inappropriately retaining a fee, lack of remorse, or other more serious issues, we don't want to have the responsibility or the burden of proving those by clear and convincing evidence. We want to sort of slip those in at the end and get the benefit of that in sentencing, but not have the burden of proving that, meeting our burden as essentially the prosecutors here. That's a little problematic to me, and I'm not hearing from you a clear argument as to when clear and convincing evidence is required to prove aggravating circumstances that weren't charged and weren't subject to the clear and convincing evidence burden during the hearing.
So my argument is that clear and convincing evidence is not required to prove.
Never, ever, except to the extent we've
never.
already said, yes.
Right, except in those special circumstances. And I understand the concern that disciplinary counsel could charge something and really be seeking to prove a different violation, but on the other hand, if we apply a clear and convincing evidence standard and we require disciplinary counsel to go into a hearing and say at the outset, before it knows what the evidence has come in to be, these are all the aggravating factors, and
Well, that may be true. I guess what's troublesome here is that everything that's listed as an aggravating factor, correct me if I'm wrong, was known prior to the hearing by disciplinary counsel.
That's true,
So there were no
and that's-
surprise, perhaps there's an argument to be made of some bombshell that only comes out in the course of the hearing that is so much more serious than what was charged. But that's not the case here. This is information that was known, and we're not even sure, as Judge Ruiz pointed out, that there was a showing made of the requirement for Mr. Schwartz to return any portion of the initial contingency fee.
Right. Okay. Let me take that question in 2 parts. The second thing that you said.
There was 2 questions, in all fairness, rolled into one.
The second thing that you said about there not being a requirement that he return the fee, that's not what was relied on here, and I'd like to get to that.
So what
but-
was relied on? Because there's all this stuff about he didn't return the fee. What are we supposed, and why is that an aggravating factor, that he didn't return the $2,000, unless he had to?
It's not. It's an aggravating factor under the prejudice to the client, and what the hearing committee found was that the client had to pay an extra $1,000 to his new attorneys. The client the client suffered extensive delay, and the
Isn't
client.
it prejudice to the client only if, well, I'm a little unsure how it is prejudice to the client unless the respondent was, ought to have repaid it.
Well, it's the hearing committee. What I understand their reasoning to be was that the $2,000 was paid to respondent, and the client received no work product and no money back. So the client was out $2,000 without any work product to show for it.
When you
And
say no
that was
work
what they
product,
called, that was
No-
what they
no
called
work
prejudice.
product. You mean they didn't get documents? That doesn't mean that Mr. Schwartz didn't work.
That's true. So it doesn't mean that, Mr. Schwartz might not have earned the fee. What it means is that the client was out $2,000 and did not have any work product to show for it, which Mr. Schwartz would not turn over to the client. And
So
so
are you
that's the-
saying that if we're trying to consider whether that's an aggravating circumstance or not, and how, if it is an aggravating circumstance, how strong an aggravating circumstance it is, we should be viewing this as a case where Mr. Schwartz may not have really been required to turn it back at all. It may have been entirely appropriate for him to have kept this amount. But nonetheless, he didn't, and therefore, it's some kind of prejudice. Is that how you want us to be looking at it, or do you want us to be thinking he actually should have returned it?
the way I'm asking you to look at it is from the client's perspective, and that's why I'm tying the two things together, the work product and the money. Either the $2,000 or some portion of it should have been returned, or the work product should have been turned over. But at the end of the day, the client had nothing, and the prejudice that the client suffered was getting nothing for $200.
Because the board's analysis of burden of proof leaves me with some questions. But with respect to this particular feature of things, the returning of the fee or not, what the board said on page 10 of its report and recommendation was the hearing committee wasn't asked to determine whether respondent should have returned his fee or whether the retention of the fee was improper, and it did not do so. So it seemed like the board was taking as a case where there's this dispute about an aggravating circumstance. The hearing committee didn't make findings about it, and the board seemed to think, well, that was somehow an impediment to the board addressing the matter. Do you agree that that seemed to be part of what's going on with respect to that particular circumstance?
It's possible. What we're arguing is not that could not be considered. What we're arguing is that the clear and convincing evidence standard of proof should not be applied to that consideration.
The reason I ask you this is because under the board rules, if there isn't an applicable hearing committee finding a fact, then the board has authority to find facts in the absence of factual findings from the hearing committee, but it's required under a separate doctrine to make those findings only by clear and convincing evidence. So I was wondering whether, in part, what's going on with respect to this isn't the whole explanation by any means of the board's analysis of clear and convincing evidence, but with respect to this, it seemed as though the board felt its hands were tied to a degree by the absence of a hearing committee finding.
That may be what the board, that may be what the board thought, and what we're saying is that the facts that are necessary to evaluate the prejudice are found by the hearing committee. We don't need that additional fact that says that the respondent didn't earn the fee to know that the client was prejudiced when he had to pay an extra $1,000 to his new attorneys, when he suffered extensive delay of his petition, and when he shelled out $2,000 and then did not get work product or any of the money back. Those three things the hearing committee found were prejudiced. The facts in the record support those without needing to find whether or not Mr. Schwartz earned the money.
He suffered delay as a result of, we have a violation which is failure to communicate, right? Does the prejudice have to relate back to that violation?
Does the prejudice to the client is just an evaluation of whether the client suffered prejudice as a result of the respondent's actions and the misconduct that he was.
The respondent's violation of the rule.
That he was charged with.
Yes,
That
as
he
a
was
result of
charged
that.
with. Okay.
I
And so he was
suppose.
charged with failing to communicate, okay, over a period of time.
Mhm.
And you're saying that it was as a result of that failure to communicate that there was a delay? I mean, I'm trying to tie back
So-
that and the other payment to the
It's-
failure to communicate.
It's not all supposed to be tied to the rule violation. So it's two separate analysis of whether we proved by clear and convincing evidence that a rule violation occurred or the rule violations that we've charged occurred. And then the sanction analysis is a much more broad analysis that goes to figuring out what this particular respondent, what their misconduct was, where it falls on the range, and it's supposed to achieve the goals of the.
I hear what you're saying, but it's troubling me a bit because and maybe I'm misunderstanding what you're saying, but you seem to be saying we can narrowly prosecute this minor violation, and we can have a very narrow hearing on whether this violation occurred, and put on narrow evidence targeted to this violation, and have the hearing committee make findings and on whether there was a violation of this one rule. And then we can just bring in any and everything, throw the book at this person in a later proceeding that has less stringent burden of proof requirements on us. And I find that a little concerning, that I think there does have to be some nexus to the prejudice and the rule violation that's charged and the rule violation that's found. And while there may be an opportunity to bring in some additional factors as to show aggravating or mitigating circumstances, can they be so totally disconnected from what was originally known and charged at the outset?
So, and I believe your question goes back to Judge McLeese's question, which is, are we going to be able to charge this small rule violation of smaller rule violation of 1.4A and ask for a greater sanction based on the 8.4C dishonesty idea? But the range of sanction
Which is uncharged.
which was not charged, but the range of sanction for the 1.4A violation, we're saying is informed admonition to maybe a public censure, and the informed admonition, I'm sorry, the 1.4A and the 8.4C would, I mean, dishonesty ranges from informed admonition all the way to disbarment. And we're not saying that we could come in and argue that we haven't charged dishonesty, but this respondent looks like they've engaged in dishonesty, and therefore he should be sanctioned for 2 years. We're saying only that it should be moved along the range of the rule violation and the similar misconduct that has already been established, so capping it at public censure or 30 days.
So you want us to write an
or
opinion that says no matter what the other aggravating circumstances are, a violation of Rule 1.4A can never result in a harsher sanction than public censure?
No.
Is that disciplinary counsel's position?
No. What I'm doing is I'm trying to identify a range
Well, I thought you said
similar.
the range was from informal admonition to public censure, and so that means the logic of that is that's the range, and no matter what the circumstances are, you can't go outside that range. The other aggravating circumstances.
I don't think that's what our case law, the way our case law has evolved. I would say
thought I understood you to say something different, that our case law has only supported a range of sanctions for violation of Rule 1.4 that includes only informal admonitions.
Okay, so
I don't see any
let me be
case
clear that
support for anything
what disciplinary counsel's argument is that the current range right now is informal admonition to public censure. The current range may actually be informal admonition because this is the first case where an informal admonition for 1.4A has come up to the court. But what we're saying is we think it's reasonable that a range would be informal admonition to a public censure of 30 days or something around that nature, on the lighter end, not talking about 2 years or 3 years of disbarment. But what this court said in Goff when it first disbarred somebody for dishonesty was that, even though someone has not been disbarred for dishonesty previous to Goff, we think that this is the most serious dishonesty that we've seen to date, and we're going to say that this warrants disbarment, and now, after Goff, the range reaches all the way to disbarment.
So just to make sure, you think, imagine, in a case in which the only charge disciplinary counsel reasonably could go forward with is, at the time of charging and at the time of the hearing, is a violation of 1.4 about communicating with clients. And then, at the hearing, it turns out that, let's say, as a surprise, the respondent admits that the respondent had lied to a court under oath about the circumstances of the lack of communication. And then, although there was that moment of candor, it's the determination of the hearing committee that throughout the proceedings, in front of the disciplinary proceedings, the respondent was lying repeatedly in egregious ways. your view is that the harshest, you couldn't really have a significant sanction for that if the only charged offense is Rule 1.4A, the only charged infraction or rule violation. No matter how egregious those circumstances are, it's got to be on the lighter side, and no matter what, the most it would be, maybe public censure, maybe, I'm not sure, you might think it might creep a little bit beyond that. Is that your position?
The due process, it brings up a due process issue of notice. What we would say, if there was no due process issue there and the respondent was on notice of that this was going to be an issue in the case because it was somehow relevant to the other charges that were charged and that evidence has come in, then what you say is interesting. I mean, maybe if disciplinary counsel did prove by clear and convincing evidence that there was this dishonesty, then maybe, and it was not a due process issue.
Why do you say clear and convincing evidence? Are you implying that might be another special circumstance, or we would impose a heightened burden of proof?
What I'm saying is if the court is concerned that it cannot impose a greater sanction in that sort of case, if that's the circumstance where the due process is not an issue and the client, the respondent was aware that it was an issue, notice it's not an issue, then perhaps maybe another answer is that if the aggravating factors were proved by clear and convincing evidence, and notice was not a problem, then maybe that range could be expanded and to something higher than the normal range. But if it's not clear and convincing evidence, if we're not relying on clear and convincing evidence, if we're just doing the normal weighing of the sanction factors, then we should be limited to that range. And so what the court did in Waller was it looked at whether there was a conflict of interest violation that was not charged and added that as an aggravating factor that it considered in determining what the sanction should be. In Schlemmer, the board did the same thing. The board considered an intentional 1.3b violation and said, we don't find that it was a 1.3b intentional violation, but we consider the fact that it was close, and we take that into consideration when we're issuing the board reprimand. And that's another option here. The board reprimand, we think, is also within the range. But again, the reason that disciplinary counsel is here is to defend the process of the sanction, determining sanction, and we think that clear and convincing evidence has not been a standard that's been applied to disciplinary counsel, that it's a strict evaluation of what's in the record, the relevant evidence that's come into the record to achieve the goals of the purposes of sanction, which are to protect the public, the courts, the integrity of the profession.
Aren't you reading too much in what the board said? Aren't you reading too much into what the board said? What the board said is, we think that there are due process concerns. There might be due process concerns if the sanction is going to be increased based on what the board thought the argument was, which was not prejudice to the client, but failure to return the fee, and that was in itself a violation of a rule which had not been charged and which had not been adjudicated. And they said, we're not going to increase the sanction based on that unless where there has been no clear and convincing evidence of that violation.
That's correct.
That's what they said, right? They didn't say from now on forevermore.
Well,
You're going to have to, if you want to show any aggravating factor, it has to be proven by clear and convincing evidence, right?
I think what they said was closer to that second statement that you made.
You think so?
Yeah, on page 8 of the board's report,
Page 8 of the board's report.
they say by analogy to evidence used to establish a fitness requirement or dishonesty, uncharged misconduct considered an aggravation would have to be proven by clear and convincing evidence.
Uncharged misconduct.
Uncharged misconduct, correct.
Uncharged misconduct.
Correct, and
But now, today, you're saying we don't have to do that. This is about prejudice to the client. And it's like ships passing in the night.
no, I'm sorry, that's not, there are 6 separate sanction factors.
I know,
Uncharged,
but which one are you relying on?
they're all 6
All
of them.
of
For this case, to determine the appropriate sanction, and for all cases, to
No,
determine the
we're talking
appropriate.
about Mr. Schwartz's case.
Okay,
Which of the aggravating factors are you, or, because actually aggravating factors is is another one at the end.
Right.
What in particular, 'cause you were just talking to us about prejudice, delay, had to pay another $1,000.
Let me see if I
Okay.
can fit these in to the sanction factors for you, because what I'm saying is that they're not aggravating factors. These are sanction factors that can be
Right.
mitigating, can be aggravating, depending on the evidence that's in the record.
understand
And
that.
here, there are 6, the nature and seriousness of the misconduct. So here, respondent is arguing that his misconduct, his failure to communicate was only 3 months. The hearing committee, the board, and disciplinary council are arguing that the failure to communicate lasted a year and a half. So we're saying the nature and seriousness of the misconduct on that factor, we want to move it towards the harsher end of the sanction. The prejudice, respondent is
Just
saying
slow down for a second, and you agree, the board didn't apply a clear and convincing evidence standard to that topic.
the board did not.
Because the board, to the extent it was articulating a rule, tied it to circumstances in which the conduct at issue was a rule violation of its own that could have been charged, that was not charged.
That's correct. And once again, if I can get to that issue of the uncharged conduct, because it's number 4 on the sanction
Right.
factors. The number 2 is the prejudice, where Mr. Schwartz is arguing that there was no prejudice to Dr. Chin. The hearing committee found that there was prejudice to Dr. Chin. The board found that there wasn't. Disciplinary council is arguing that there was. And that prejudice we've discussed already today. The number 3 is the conduct not involving dishonesty. There is no dishonesty in this case, and there's no dispute about that. Number 4, and here's where the uncharged misconduct comes in, violations of other disciplinary rules. And again, that's what's discussed in Waller, that's what's discussed in Slimmer.
Can I just make sure, before I go back, you say that the board found there was no prejudice to the client in this case?
I believe so. I believe the board found that there was no prejudice to the client and did not agree with the hearing committee's finding of the prejudice.
Well, I'll have to look further, but in the paragraph where they talk about returning the fee, they say some things about basically saying we don't really see a violation here. It wasn't shown to be a violation. But is there another discussion where they say no prejudice also?
I'm sorry, what page of the board report?
What page of the board's report and recommendation would you say is the place where the board found that there was no prejudice to Mr. Schwartz, to Mr. Schwartz's client?
If you look at the bottom of page 22, they refer to what the hearing committee said. Said that the-
22?
22. It says, at the hearing committee notes that the prejudice suffered by the Dr. Chen was not de minimis. He had to pay an additional $1,000 to the University of Pittsburgh. Respondent not return the $2,000 retainer fee, and respondent knew that time was of the essence for Dr. Chen. We accordingly do not agree with respondent's position on that point.
I'm sorry, I'm not on the same page as you. I'm sorry. I have.
Right, I was asking about what the,
This is the board.
no, I think that's the hearing.
My
That's
board
the
report
board.
doesn't have 22 pages. My board report has 14 pages.
This is the order of the Board on Professional Responsibility.
Yes.
The ad hoc hearing committee.
The hearing committee, you're talking about?
Oh, I'm sorry, you're correct. This is the hearing committee.
Okay, so
You're right.
to Judge McLeese's question, on page 10 of the board report, they say, accordingly, we do not find disciplinary counsel proved this potentially aggravating factor by clear and convincing evidence. They're talking about the prejudice, and they say it would be inappropriate to rely on the fee.
In terms, they're not. I mean, the whole paragraph is about failure to return the fee.
That's true, but then they go on to talk about, let's see if it's in a footnote.
So they clearly found that failure to return the fee was not an aggravating circumstance. I don't know that they expressly said in no way was Mr. Schwartz's client prejudiced.
That's true, but they considered maybe they considered the delay, but they did do away with the additional payments and the failure to return the documents. They claimed that Dr. Chen, because he had decided to pursue another avenue, was not prejudiced by not getting his documents from I believe that was in a footnote, but they claimed that because Dr. Chen had gone another route, he then was not prejudiced by not getting his work product back. And we dispute that. We think that regardless of the route that Dr. Chen was going to take, he deserved to get the work product back from his to get the work product back from his attorney, and if he did not get it back, then that constitutes prejudice. But going back to the fourth factor that we were getting to on the sanction analysis, the fourth factor says violations of other disciplinary rules. So it says that in every case, the court is going to, or the board, the hearing committee is going to consider whether or not, in addition to the nature and seriousness of the violations and the rules that have been charged and proven by clear and convincing evidence, whether or not there is an indication that other rules have been violated.
Well, no, you're interpreting it that way. It could just mean, one way to think of it is to say, well, are there other rule violations in this case that have in fact been adjudicated? In other words, it's not just a 1.4, there's also an 8.4, there's a whole constellation of rule violations, and we're going to take that into account.
I'm sorry.
And you're saying, no, that refers to uncharged conduct.
Well, the first factor takes into account everything that disciplinary counsel has charged and proved. So if it's a 1.4A, 1.16D, and a 1.3, those things would be considered as part of the nature and seriousness of the misconduct.
You say that would only be
that's
under
number
that first
one.
factor.
That's number one, and then in number four, and this doesn't come up very often in our cases, and that's why
You referred to what, Waller is the one case?
Waller and Schlemmer, but it's a bit difficult to find cases that involve these facts, especially this fourth factor of sanction analysis, because disciplinary counsel usually charges all the rules, and in this case,
there's one recurring scenario, I thought. Again, maybe not always focused in this way, but there are a number of cases where the allegation and determination of the hearing committee adopted by the board is that during the disciplinary proceeding itself, the respondent made false statements, which would itself be its own disciplinary violation, but often isn't newly charged as it. So that would be uncharged misconduct under Part 4 in your view?
right, that would be
And there are a
uncharged
lot of cases that take that form, right, where that's one of the factors that's considered.
Yes, and so.
But that's one
But
where it
there's-
could not have been charged at the beginning, because it hadn't occurred.
It had not been charged, and the difference between that case and this case here is that it hadn't occurred. Disciplinary counsel wasn't aware of it at the time. The reason that we're even here today is because this is this is a rejected informed admonition. That's why I mentioned the board rule, which says that disciplinary counsel cannot charge additional rule violations after a rejected informed admonition. So that's why the 1.16D was not able to be put in the charges, and that's why the 1.3 was not able to be put in the charges. And those circumstances can happen for other reasons. Disciplinary counsel could be not aware of what the universe of the rule violations are at the time, which is what we just discussed, but also a contract member might reject some of the rule violations that we've put in our charges, so we wouldn't be able to go forward with the specification of charges without taking those charges out of the spec. And another thing is that the idea that disciplinary counsel would have to prove these things by clear and convincing evidence, and we could not rely on anything that might, in hindsight, go to a rule violation. It limits what the court is able to do in terms of fashioning the appropriate sanction for the respondent and protecting the public and the integrity of the profession, but it also promotes overcharging by disciplinary counsel so that we would have to throw in everything into our specification for charges that we thought we might have clear and convincing evidence of, and that we also thought might go to a sanction aggravating factor.
Well, overcharging sounds bad in isolation, but could you be more concrete about what you think the adverse consequences would be of a regime where disciplinary counsel had stronger incentives to bring the charges it reasonably thought were provable?
I'm sorry, can you repeat that question?
Yeah, I mean, you say the word overcharging, and it sounds bad in isolation. No one wants to overdo something. You want to do it the right amount. But I'm just asking concretely, what do you think? Assume that this court issued an opinion in this case that said disciplinary counsel is going to have to show by clear and convincing evidence any fact that it could have charged and didn't charge at the outset, if it wants to rely on it in aggravation for whatever charge was found. What concretely, how would that make the disciplinary process work less well, or in what sense would that result in overcharging that would be problematic in some way?
Well, the overcharging, we don't think that charging respondents with something that we don't have clear and convincing evidence of is a good way to operate. So we wouldn't want to bring charges if we thought that it went to aggravation of sanction. I mean, basically at that point, you're just saying we can only consider the rule violations that were charged, and anything else, any other evidence in the record, cannot be considered, even if it falls under these sanction factors that the court has said for years that these are the sanction factors that we follow. This is what we look at when we're trying to determine what sanction is appropriate and how to protect the public, the courts, the integrity of the system, and deter other attorneys from doing this. And what you're doing is essentially taking away or blunting the tool that the disciplinary system has to make these determinations and to find the right place on the range of the similar misconduct for each particular respondent. And so
Well,
getting back to...
We are limiting it because there seems to be an unfairness to it. I mean, it would be limited in that sense. I mean, you just said that once you issue an informal admonition, if the lawyer rejects it, basically forcing you to then have to charge, you can't charge anything above that.
That's correct.
Right. And then you also mentioned that, before you can bring any charges, you have to have the approval of a contact member, right?
Correct.
There's a reason for that. Those are checks.
Yes.
Those are checks on what disciplinary counsel can do and what charges it can bring.
And those, yes.
And so, I mean, there's
So-
a sense that that you would somehow be frustrating or foiling those checks that exist by then having brought one charge permissibly, you were able to, in essence, sneak in through the sanctions analysis evidence, but not by clear and convincing and not after a finding of another violation.
Believe me, I understand the
You
sense.
understand?
I understand the sense. And
You
what I'm
okay.
saying, but what I'm saying, and why I keep trying to go back to the ranges, is that there's a check on that which limits the rule violations that disciplinary counsel is in charge, and I think in turn limits the range of sanction that a respondent is exposed to. But at the same time,
that reassurance would be more reassuring if there were some well-settled top and bottom ranges. I mean, this is very analogous to the federal sentencing guidelines and similar considerations there. But in those settings, there actually is a statutory range at the front end and the back end. But I haven't really heard from you today, at least, much of a clear assurance about what the top range is for a violation of 1A. And what's the highest sanction you could ever impose, no matter what the circumstances were? Is there some? Can you tell me what that range is?
What's the highest sanction that could ever be imposed for a 1.4A communication violation?
No matter what, no matter how many times the respondent gets up and lies to the hearing committee during the proceeding, no matter how much it's determined that unbeknownst to disciplinary counsel, there had been lies to courts about it, and no matter how severe the prejudice is, you're saying the highest sanction is X. What's the range? What's the top range that you want us to rely on for reassurance purposes here?
Unfortunately, our ranges don't work like that, and we just don't have a range that's set forth by statute or something. We just don't have that, and so it's more of an art than a science. The court has said in the past that you're looking at these things and you're looking at the whole stew and trying to figure out what is the correct thing for this respondent. And I can't say what that top range is. What I'm saying, the best I can give you right now is I think that the range should be an informed admonition to around a public center or a 30-day, but nothing. That's about the range for this type of misconduct. But then a respondent could come along and you have a single 1.4A violation, but it lasted for 10 years and there are all these other aggravating factors, something more akin to what happened in Gulf, where the court had never seen the like of the dishonesty before. And I can't say that that case won't come before the court, and the court won't want to say, we're deciding now that the range for a 1.48 violation is going to be higher because this misconduct simply has to be disciplined, sanctioned at a higher level because we need to protect the public, the courts,
All
and the
right,
integrity of the
Mr.
system.
Lowry, I think we have your argument, and we have certainly asked you lots of questions, and we've gone well over your time here. So we'll give you an opportunity to respond further in rebuttal, and I'd like to hear from Mr. Schwartz at this time.
Thank you.
Thank you.
Good morning, Your Honor. May it please the court, I'm Frederick Schwartz, and this is the point where I normally say who I represent. In this case, I'm not sure. If you look at the caption, I'm disagreeing with the position of the board, and I'm disagreeing with the position of disciplinary counsel, and obviously that isn't correct. On the other hand, when I believe my brief was supporting the board, and in essence,
Counsel,
on behalf of...
whoever you agree with or disagree with, the only person you're representing is yourself. I mean, there's no way you're representing the board, even if you agree with them, right?
Well, I understand that, but the board has written 2 letters to the court saying that my position does not represent its position, and I do not speak for it. And the point I raise is merely to address that fact. But the main point that I made in my papers was that the issue, the dispositive issue in this exception by the disciplinary counsel is the issue of waiver. And this is an issue which they think makes no difference, but it's very clear that it is.
Can you tell me further what you mean by waiver? Are you saying that disciplinary counsel is never able to raise other factors that could be aggravating factors in the sanctions determination phase that they haven't charged?
No, I'm saying just the opposite. Under rule, and I have to thank disciplinary counsel for pointing out their actual rule number to me. Under Rule 1111 and 1112, there is a process that follows an initial disposition, an initial finding. So what happens is there's a factual hearing, the hearing's over, the hearing committee meets privately, and they reach an initial determination. They reached an initial determination in this case that, in fact, I had violated that particular rule. And they really had no choice because throughout the proceedings, I said that I had violated that rule. Then they come back and they ask counsel, is there any evidence on waiver? I'm sorry, is there any evidence on aggravation or mitigation? And they asked that question. And Ms. Tate said, and I want to quote because I misquoted her once in my papers, our counsel will indicate we have no evidence in aggravation. And then I explained that I wasn't aware of the rule, and they allowed me to submit something, but I didn't because there was no aggravation which needed to be mitigated.
Can I ask you, I mean, your opponent argues that that may be a little bit inartful, but one natural way of reading it is, because the preceding question is, does anybody want to offer some evidence in phase 2 of the proceeding? I'm paraphrasing. And your disciplinary counsel argues, understood in context, what counsel was trying to say there, if not clearly, was I don't tend to introduce any further evidence, rather than saying we're not going to argue that any of the circumstances previously elicited bear or aggravating circumstances. Why are they wrong that that's at least a reasonable way of reading what was said there?
Well, because quite frankly, with all respect, Judge McLeese, it abandons English. Plus the fact it was consistent with the questions that were asked of me and the representations made during the hearing. The representations made during the hearing was this case has nothing to do with anything but a failure to communicate.
Can I
It
ask
was
you, so following the procedure out, you followed that up by saying that you were unaware of this process and that you might well want to introduce, you want to leave at least to introduce mitigating evidence, and you said you ultimately decided not to do that. There came a time in front of the hearing committee where in post-hearing filings, disciplinary counsel indicated that it thought there were some circumstances that were germane to sanction that had already been supported by the evidence admitted in the violation phase of the proceeding. Is that right?
She said, Bar Counsel will indicate we have no evidence in aggravation.
My question is about, didn't there later come a time when disciplinary counsel filed a document post-hearing, pre-ruling by the hearing, or pre-report and recommendation by the hearing committee, where it indicated here are some circumstances that we believe are aggravating of sanction?
Well, she in fact developed post-hearing or attempted to develop post-hearing aggravation. And there is a footnote where in fact the court, or rather the hearing committee rejected that. The only logical meaning is...
Just to slow down a little bit, is it correct that there was a filing by disciplinary counsel after the hearing, but before the hearing committee gave its report of recommendation, where disciplinary counsel said, we think that this is not just a run-of-the-mill failure to communicate. Here are the circumstances that we rely on to warrant a harsher sanction under the sanction analysis. Is it true that there was a document of that kind filed?
Oh, I do understand that. In fact, Judge McLeese, there were two filings.
Right, and so you were aware by those filings that that's what disciplinary counsel hoped to do?
Well, I was aware that they were attempting to enlarge the penalty, a penalty which they in fact had previously recommended. They were attempting to enlarge the penalty in a way which I thought was inconsistent with representations made during the hearing.
Right, and after the filings by disciplinary counsel to that effect, did you say to the hearing committee, hold on, hearing committee, A, I think this was waived, and B, if you're going to consider any of this, this has been unfair, I need an opportunity to confront the evidence being relied upon by disciplinary counsel, so reopen the hearing, allow me some kind of process so that this will be fair?
Well, that in essence is the Austin case, and I don't think that's the representation I'm making.
I'm not asking about some other case, I was asking what happened in this case. Once you became aware before the hearing committee ruled that the hearing committee that the disciplinary counsel was going to try to rely on previously elicited circumstances to aggravate the sanction, did you say to the hearing committee, don't do that, they waived, and if you don't agree they outright waived, at least I need to have some kind of fair process where I get a chance to confront this evidence and either put on my own responsive evidence or cross-examine their evidence or do something. And so I'm asking about this case, did you make such a request of the hearing committee?
No, because it wasn't necessary, and the argument that I made was more than it was just waived. The argument I made is they waived it, and even if they hadn't waived it, they made representations during the hearing that in fact they were going to, A, they were not going to rely on it, and B, that it didn't matter. For example, throughout the hearing and the proceedings before the board, Ms. Tate, who was actually disciplinary counsel below, said, it doesn't matter to us whether or not he did the work. It doesn't matter to us whether or not he was entitled to the $2,000.
Understood, and it seems to me as though if you later became aware that for sanction purposes they were acting like it did matter and that you hadn't had a fair opportunity to address those circumstances factually, that one of the points you would make is, that's just not fair. I haven't been able, they said it didn't matter. We didn't develop a record on it. Don't go off on that factual circumstance without giving me additional process. So I would have thought it would have been a point, if you thought there was something further you could do about any of that by way of evidence, I would have thought it would have been very much in your mind to try to make sure the hearing committee didn't accept disciplinary counsel's view as it was being expressed in the sanction filings.
Well, I would in fact have made better evidentiary showing in the hearing itself. But I don't think, in all fairness, that I could rely on that solely. I don't think it's a matter of surprise, because each of the things that they mentioned were in fact entered into evidence and accepted as evidence in the hearing. They didn't say anything, quite frankly, that surprised me. What was a surprise is they said it didn't matter. And that it wasn't so much of a surprise that they said it. What was a surprise is that they argued it.
So are you saying now that you aren't really practically prejudiced by these representations in the sense of being able to meet the factual assertions of disciplinary counsel, and instead your point is, it sounds like it's almost more an estoppel, partly waiver, but to its extent it runs beyond that, it's almost like an estoppel argument that in fairness, having said what they said, they shouldn't be allowed to change course? Or do you actually think you were somehow practically prejudiced in the respect of being able to factually address the circumstances disciplinary counsel was relying upon to enhance sanction?
Well, I think that's behind it, but my argument about it being dispositive is, in fact, the rule was violated. And if the rule is violated,
Which rule, I'm sorry, are you referring to
okay,
being violated?
Rule 1111, which is bifurcated hearings, and Rule 1112, which is waiver of right to present evidence. And what that in essence, and what in essence happened is what Chief Judge Barnesman-Rigsby believed was a problem, and that is that they said, we don't have any evidence of aggravation. They have nothing in the record so far that we can argue was aggravation. And that's what the rule is getting at. And then they say, when they file their brief, oh, we've changed our mind. We think that, in fact, the evidence in the record demonstrates that there was aggravation. For example, prejudice. And in terms of that particular argument, I disagreed with the conclusion of the hearing committee. The board adopted it. I did not base an appeal on it because it was, in essence, harmless error. But in fact, there was no prejudice. If I had the first or second time during that 3 or 4 month period gotten an email from him and I'd responded, as you know, my Chinese legal assistant left. I'm having trouble finding your file. I will get back to you as soon as I can. There would be no infraction.
You referred to a 3 to 4 month period, and that's an area of dispute because the hearing committee and the board viewed the relevant period of failure to communicate as, I forget, but I think more like 16 months. So if your prejudice analysis, that piece of it at least, seemed to rest on a factual view about the extent of your rule violation temporally that is inconsistent with what the hearing committee and the board understood to be the case.
That's correct, but they mistakenly did that. And if I had to appeal, if I thought that was relevant, I would have pointed out that the rule requires me to use my Chinese legal assistant to communicate as I would if it were email, as I would if in any way whatsoever. And in fact, I did communicate when he came to the office. He never asked to speak to me. I spoke to her about the case. I received the papers that she solicited talking about my Chinese assistant. I reviewed them. I gave her my response to transmit to him. So it was clearly an inappropriate decision, just like it was an inappropriate decision to say that I should have returned the $2,000. In fact, he suffered no prejudice from that because it was my $2,000. I never got the final $2,000 because I never did the work for it. He paid $1,000 for the second part of it.
Well, I mean, it seems like there's a pretty easy way in which to view your former client as having been prejudiced. At the end of the day, your client found someone who for $1,000 would actually solve his immigration problem. But because he ran into you first, he paid you $2,000 and got no benefit from it. So that seems on a pretty straightforward way of looking at prejudice. It seems like one would view your client as worse off from his encounter from you. He gave you $2,000, got nothing from it. Why isn't that prejudice?
Well,
You got
because,
nothing of value to him from it.
because he isn't worse off. I did the initial analysis. He's the one that precluded my continuing. And as the record shows, I offered to continue the case under the same terms.
Well, you say continue, part of the.
Continue to represent him.
Continue
When his file was found,
to move it from the extremely lengthy queue, or I'm not sure quite what you mean when you say continue the work.
well, I was finishing up my national interest cases because I no longer could do them since I had no assistant, according to the government, and was not permitted to have an assistant. So, so it would have been removed from the queue, and I would have, in fact, because of the delay, immediately went to that particular case and done that case. He, on the other hand, had already gone to the not the student center, but the big universities have a center dealing only with international students, graduate and non-graduate, and also work permits for.
Is it part of your point today that you think your client unreasonably responded to the failure of communication that you concede existed by kind of giving up on you and trying to find somebody who would do the work? Or do you think it was, would you acknowledge that it was reasonable of your client to respond the way your client did?
Oh, no, my client did exactly what was appropriate. Never during this hearing have I ever blamed him for any action that he took. And I've made that clear in my testimony and in my filings and in my cross-examination of him.
Mr. Schwartz, did your client, Mr. Chen, ever explicitly request that you refund the $2,000 retainer fee?
Well, I don't think he actually requested it, but he did at some point. And whether it was before he said, well, I guess the answer is no. He didn't request it when he terminated me, I don't believe, and he certainly didn't request it when I called him up and said, I'd like to continue, and he said, well, let me see the cover letters and then I'll decide whether I'll continue with you. Because that would be inconsistent with saying, anyhow, just send me the $2,000. I see that my time is up. There were other questions that.
So you are requesting that there not be even an informal reprimand?
I'm sorry.
You're
Even though I
agreeing
got
with-
something
I'm
to
sorry.
help, I can't
You're
quite hear.
agreeing with the board's recommendation,
That's right.
informal admonition, excuse me.
That's right. I am here solely to defend the board's decision, even though I do not fully agree with it.
Okay.
But you have, like you said, you have acknowledged a violation of 1.4A. And I take it you're in no way fighting that an appropriate sanction for that is an informal admonition.
The reason I'm hesitating is that my position before the board was that prior to the change in the board rules based on the ABA, that an informal admonition was in fact an informal admonition. Consequently, because of the rules change, it was elevated to a public censure, in essence. And this court was stripped of its ability to review a decision to publicly censure anyone. But
Okay, the one thing you said has puzzled me. If what you're saying is because of the rule change, because of the changes about more informal admonitions that were maybe private admonitions, there's really no practical difference between an informal admonition and public censure. then I'm not 100% sure why you're here or why any of us are here, because that's the actual dispute about what people want at the end of the day in the short run in this case, leave aside broader issues, is about that difference, right?
Right. The reason I hesitated is because I intend to submit a petition to the Rules Committee to alter that. And I didn't want to be bound by making a representation in this court that I thought the current public emulation was in fact an appropriate standard to apply.
Can I ask you the question? Do you think there is a practical difference in this case to you between getting an informal admonition under the way that now functions and being publicly censured?
Well, the answer to that question is I don't know. I think in terms of my ability to get clients, there is no difference. I think there were differences which were just articulated by disciplinary counsel, and there may be differences. But that's not why this whole case was brought. They initially suggested that it should be an informal admonition. But I did not agree to the narrative that they wanted to include in the DC Lawyer about how I had for years not communicated with my client, and then my client fired me and was wandering through the campus one day and found a couple of students who did it for $1,000. Most of what they said could not be factually supported. And so I had to bring it before the board.
Did the board, as far as you know, or the hearing committee, I guess, or the board, consider, I know you didn't specifically put on any evidence of mitigation, but did they consider mitigating factors such as you haven't had any prior disciplinary?
No, because there is no mitigating factor for what they imposed. It is the lowest range. Plus the fact that I did not offer any mitigating factors. I did not offer any mitigating factors because Ms. Tate said, I have no evidence of aggravating factors. So I had no aggravating factors to which I needed to negate. And therefore I did not offer that evidence.
All right. Anything further, Mr. Schwartz?
I don't believe so. It's so unusual that I don't have a chance for rebuttal, but I think I'm okay.
All right, thank you. Mr. Lowry? I'll give you a couple minutes for a brief rebuttal.
Thank you. I know I've taken a lot of time, but I just want to point out four things. The first thing is Mr. Schwartz relies on the disciplinary counsel's statement at the end of the bifurcated, or the middle of the bifurcated proceeding, I suppose, the end of the first phase, where we said that we did have evidence of aggravation. And I just want to point out that that's the same, if not the same statement that happens in almost every case. Disciplinary counsel usually does not have any additional evidence unless it's prior discipline. And I want to point to Board Rule 11.
If the point you're trying to make is you plan to seek, you believe you may well be seeking an aggravated sanction, but you don't intend to introduce any additional evidence at a separate phase 2 of the proceeding, that would be a lot clearer way of saying it than if this is the way it's generally said. That's maybe not the clearest way of saying it.
Well, I think one word was missing, was additional. I think the clearest way to say it is we have no additional evidence in aggravation. And I want to point to
and when you were saying this is the way it's normally said, is it normally said with or without that word?
I don't believe that that anyone accords that statement that much importance. That it is.
I'm just asking you a specific question. You said, this is the way it's always said, and I'm unsure whether when you say this is the way it's always said, it has or doesn't have the word additional. You're making a representation of how it's typically said. What I
mean is that statement or something similar to that statement is usually said, and the reason why it's said that way is because Board Rule 11.11 says that after the first phase of the bifurcated proceeding, the hearing committee shall resume the hearing and permit disciplinary counsel to present evidence of prior discipline, if any, and also shall allow the respondent to present additional evidence of mitigation. And I think what that shows is that they're focused on the prior discipline, which is the only thing that would be coming in at that second phase, because everything else would have come in at the first phase of the hearing as relevant to the charges in some way. And that's where the analysis of that's why analyzing the sanction factors, you're analyzing things that have come in as already relevant.
Mr. Lowry, I'm sorry, could you go back to what you're saying? That I don't have the language of 11.11 in front of me, but what you just read seems to suggest what we have been concerned about, which is that in this, when you move to the second stage of the bifurcated proceeding about sanction, and you are introducing new evidence or evidence regarding aggravation, that's typically where you would introduce evidence about prior rules violations that have been charged and found against a particular
No, that's not what I'm saying. What I'm saying is prior discipline is whether this respondent, for example, if Mr. Swartz had back in 1995 been found to have engaged in misconduct and been suspended.
That's what I just said, I think. That's what I meant.
No, I thought you were saying, okay, if that's what you meant.
Prior discipline, meaning prior
Prior
discipline,
found
findings
by this
of a
court.
rule
Yeah.
violation, and where the hearing committee has found evidence to support the rule violation.
Right, but not in that specific, right, exactly. Not in this case, prior discipline in a separate case. Yes,
Right.
correct, sorry.
Okay, so here, the problem, or the issue of concern that I have, and I think has been raised, is that rule deals with prior charged violations, and here you sought to bring in evidence at this stage in the proceedings of aggravating factors relating to uncharged, and this is what the board, I think, expressed concern about, uncharged rule violations that could have been charged and were known in this proceeding.
So I'm a little confused by your question, but there's no, in this case, we did not introduce additional evidence of prior discipline because the respondent did not have prior discipline. So that's one of the factors that's considered under the sanction factors is whether there's prior discipline, but the prior discipline that a respondent might have is not a relevant thing that comes in the first phase of the hearing. It's not relevant to whether he violated 1.4a.
Right, and
Whereas,
I'm not disputing why evidence of prior discipline wasn't brought here, because there is none. What I'm saying is the rule 11.11 that you just read seems to suggest that that is the kind of information that's appropriately brought in that phase of the proceeding if it exists, not uncharged evidence that was known that might relate to other rule violations.
right, uncharged.
Which is what was brought
uncharged-
in here.
No, it wasn't, nothing was brought in the second phase. Uncharged misconduct, all the evidence that we're talking about here came in the first phase of the bifurcated proceeding. And so everything that we're considering.
You argued it. I mean, like you said, it's a bifurcated proceeding. The second part has to do with sanction.
Yes,
It might require further evidence, or it might not, but you still present the argument.
Okay, so
at
you're
that
including
point,
the
And you might
briefing.
be well, I'm asking you, isn't that what the second phase of the proceeding is about? It could include a hearing to add additional evidence.
the post-hearing briefs are where the parties generally address issues of aggravation and mitigation.
Right.
And those are arguments as to the evidence that's already in the record, saying this evidence, such as,
You made arguments about violations of Rule 1.16, a new rule violation. You
We
made
ma- we
those
made argu-
arguments,
we made
but
arguments
based
about-
on evidence that was already heard in the first part of the proceeding, but not charged as a separate rule violation.
I'm sorry, we made arguments about prejudice and failure and lack of remorse and the nature and seriousness of the misconduct. We did not, in this case, make arguments about violations of other disciplinary rules, but the board has said that we can't consider anything that would be prejudice, anything that would be lack of remorse, or anything that would be, that go to the length of suspension, if it overlaps with something that could have been charged as another rule violation. That's where things are
I have
getting
to go
kind of.
back and look at your filings at the sanction phase. But you're saying right now that in none of them did you point out that some of the circumstances you were relying on as aggravating the sanction that otherwise would have been appropriate actually were themselves violations of separate rules.
I can't say that for certain. We may have said that.
You just said that in response to my question.
My recollection, I can't say that it was never mentioned that it could have been a 1.6D. I can't say that and I don't want to misrepresent the record, so I can't say that for sure. But what I'm saying is that our argument was always that there was prejudice in this case, and that's what the hearing committee found, that there was a lack of remorse, which they didn't find, but we argue that there was. And we think that those things have to be considered under the 6 sanction factor analysis. And the issues that respondents has raised as far as notice go to, we have to talk about the board rule 6.4 that says we can't add additional charges, but we also have to think about the board rule 6.5, which says that an informal admonition, if rejected, can result in a higher sanction. And in this case, the things that the respondent rejected the informal admonition based on, the reasons he rejected them, were the very things that the committee relied on in looking at the sanction and saying, in evaluating the sanction. And they're the very things that we are saying should be evaluated and given the weight they deserve to find where this conduct falls on a range of sanction. And if we're
if you could help me with one practical question. If we ordinarily are going to defer to the board's recommended sanction, subject to certain exceptions, and if, leaving aside all these procedural discussions, it's an aspect of your point that if you look at this record correctly, it really calls out for public censure rather than informal admonition. Assessing that, which of those sanctions is more suitable for the conduct if we were viewing it the correct way, requires some sense of what the actual different consequences are of those two kinds of discipline. And do you think there is a significant practical consequence or difference between those two sanctions?
I do think there's a significant difference between a public censure from this court that says that we think that this is more than an informal admonition that's issued by disciplinary counsel. We think that this misconduct is more serious and warrants something that's going to be published in the A2nd. I think that is that's a more serious sanction that carries greater weight. And it might not be the difference between informal admonition and 2 years, but there is a big difference between the public censure and informal admonition. And when you get to, I guess, the main thing to look at in this case is the sanction factors. And I keep coming back to those sanction factors because those are what the court has used in all of its cases. And in this case, 4 of the 6 sanction factors, we say 4 of them, nature and seriousness of the misconduct, the prejudice, the violations of other disciplinary rules, and the acknowledgement of the misconduct, 4 of those 6 counsel moving toward the higher end of the range. And if 4 out of 6 say move towards the higher end of the range, the only way to stay at an informal admonition, which is the lowest sanction available, the only way to stay there is to say that really that's the only thing you can get for a 1.4a violation. And we don't think that's true. We think that a 1.4a violation can get you an informal admonition and can range up to a public censure. And we're saying that those 4 out of 6 sanction factors that are counseling us to move toward the higher end should push this towards a public censure.
Okay,
But,
so you, and just now you did mention the violation of other disciplinary rules, so you are relying on that, not just prejudice.
yes, I'm
Okay,
relying.
so you're relying on that
I mean,
as a
we have
factor
to,
to be
as a
taken.
factor, I think
Okay.
the court always has to consider all of them. Whether we pointed that out specifically in our briefs below, I can't say whether we pointed that out specifically, but I am saying that the board, the hearing committee, and the court rely on these 6 factors, and all of those factors have to be weighed in determining where on the range they fall. And we think that the 4 out of the 6 point towards the higher range. And the most important thing for us in this case is that the court looks at the Waller, the Canoe case, the Schlemmer case, and which stand for the purpose that uncharged misconduct can be considered. And actually number 4 of the sanction factor says violations of other disciplinary rules.
All
And
right,
we think
thank
that
you. I think we've heard your arguments and given you additional time. We appreciate your arguments today and briefs in this matter. And we appreciate both parties' submissions. Thank you both for your arguments today. have one final matter on the calendar today, DC Department of Transportation versus Capital City Construction. All right, are parties ready to proceed?
Good afternoon. May it please the court. Carl Schifferle for the District Department of Transportation. I would like to reserve 3 minutes for rebuttal, if I may.
All right, thank you.
The Office of Administrative Hearings erred in finding no public space violation and allowing that violation to continue unabated. Despite DDOT not even being allowed to present its own case at the hearing, the evidence still established that the violation occurred, and that's because, as a matter of law, Capital City did not have a permit to construct its ramps on public space. We would ask, therefore, that the court reverse and remand so that this ongoing violation can be remedied. The violation was established.
You think it should be abated?
Yes, that is
what DDOT would want, is for the ramp to be somehow reconfigured so that it doesn't intrude into the public space.
That is correct, Your Honor, and that is what was required in the notice of violation itself. It did specify that abatement was required, and once Capital City contested the violation notice and it went to a hearing, DDOT needed to establish that the violation had occurred in order to impose the requirement of abatement. Both the Capital City would have the obligation to abate once the violation is found, and if Capital City doesn't abate the violation itself within a reasonable time of the violation being found, then the DDOT would have that right to abate it itself and then impose the cost up to 3 times the cost on Capital City. So that is why we are here.
Can I ask you, you said at the beginning that, and you argue in your briefs, that the district wasn't permitted to prove its case. And I'm just wondering, because, I mean, there's no question that the administrative law judge, after Mr. White starts testifying pretty quickly, says, I've got what I need to make my decision. And Mr. White says, okay, and I don't see a place where the lawyer for the district says, wait a minute, Your Honor, we haven't put on our case yet, we object. Where did that happen? And if it didn't happen, why didn't it happen? If you really had more evidence to put on.
Okay. There was no lawyer for the district at the hearing. It was
The
simply the
representative,
inspector.
fair enough, the representative for the district.
Right, somebody who's not trained in the law. But
Well, is it the district's view that generally people who are represented pro se aren't required to object?
my only point, Your Honor, was just that.
But I have a question about, do you agree that although the district may have chosen not to have a lawyer there, if there would be a need to have some kind of objection, that it would, the objection requirements would apply even if the district chose to be represented pro se in that proceeding?
Right, I would agree with that generally, right, of course. But in this particular situation, the ALJ made it quite clear that the ALJ was not going to be hearing any further evidence. It's clear from the transcript that the ALJ basically said, I have one question, why is this a violation? The inspector said, because they didn't have a permit. And at that point, she said, that's all I need to hear. Thank you very much. Have a good day, and just ended the hearing.
And if I'd been Inspector White, I might have thought, I'm about to win, because the issue is whether there was a permit. There isn't a permit, so I've won.
Perhaps, Your Honor, but it was clear the inspector was trying to present additional facts and information and was repeatedly cut off by the ALJ and then instructed to answer just one question. So I think at that point, you know, the inspector knew that any further attempt to introduce evidence would be violating what the ALJ had just instructed.
Would Mr. White have disputed the testimony that he gave a verbal okay to build the ramp?
It is my understanding that that is correct, that the inspector would have said that he did not approve the ramps or otherwise purport to excuse Capital City from applying for a permit.
But isn't
Is
that
that
the
a
point?
little, did he give a verbal okay that they could have ramps? Because you said he didn't approve the ramps that they built. I don't know if that's the same as him saying, sure, you could build some ramps. Maybe he thought that meant you then have to go through some additional process, but they took it as, he said, I could build the ramp. I mean, you seem to be qualifying a little bit.
Well, I mean, part of the problem is that, there is no record. We don't have a record because the inspector wasn't allowed to testify. So I don't want to commit to exactly specifically what he would say, but it would be at least a different story, and one that would be consistent with the district's, DDOT's position here, which is Capital City was not excused from applying for a permit, even by virtue of what the inspector might have said on the scene at the time.
That's not a permit.
And that's, in any event, right.
Inspector, the inspector saying and measuring and all that and saying, oh, this looks good, is not a permit.
Right, in any event, that's not a permit, because a permit, there's a process for applying for a permit. And
Has
Capital City is a sophisticated developer. They understand the permit process, and they go through
Has
it.
there ever been a request for a permit made?
I'm sorry, has there ever been a
An application for a permit made
So,
yes.
so for a public space permit, there was a public space permit that Capital City did receive related to the
Well,
construction
that
of
was a
this new building.
temporary.
But that, right, that was temporary, and it has nothing to do with the installation of ramps. As far as whether they applied for a permit for the ramps, this is not in the record, but it's my understanding that they did subsequently apply after the ramps were already in place, and that permit was not approved.
Was not approved.
Is that the same as or different from the references to trying to get some kind of what sounded more like in a variance
Like a
or
modification
a
you
modification?
referred
Or is that what you're referring to, or is that a separate track that also may not be fully developed in the record?
So I suppose they could have followed up with DDOT and said, even though this doesn't comply, DDOT, with your standards, these ramps, can you give us a modification? They could have perhaps followed up. But in any event, they didn't get a permit from DDOT. There's also separate reference in the record to this code modification that was
Right.
That's what I was asking
requested.
about.
Okay, so that was requested of the DC Department of Consumer and Regulatory Affairs. Now, that's something different entirely. I want to make clear that that would not authorize the occupation of public space. It's simply because these ramps count as a building protrusion, that there are separate requirements under the construction code, which DCRA applies, that would have to be addressed.
So just
But
to be
again,
clear-
that's a separate issue from whether there's authorization to occupy public space, and only DDOT can provide that authorization.
So there was a suggestion in the brief that that might have been, if that had been received, it might have authorized what happened here. You're saying that might have been a way of solving one set of regulatory problems, but it wouldn't have been a way of solving the public use permit issue with DDOT.
Exactly. Just because there are additional requirements they also had to satisfy, it still doesn't mean that they don't have the additional requirement of obtaining a public space permit from DDOT. And by law, DDOT is the agency that reviews, authorizes, and issues public space permits.
Which permit was the ALJ referring to when he or she said, I only have one question, was there a permit? Were they referring, was the reference to the DDOT permit?
Well, the ALJ's question, I believe, was, I have one question, why was this a violation? And the DDOT inspector replied, because there wasn't a permit. So the DDOT inspector is testifying as to the fact that there was no permit from DDOT. And so that's the evidence that's in the record, and that establishes in and of itself the violation, even though the inspector wasn't permitted to testify as to anything else. At least the evidence is clear that there was no permit from DDOT. And even Capital City essentially conceded that at the hearing by its representative stating that it wasn't even aware that it needed to apply for a permit until after the fact.
Well, and one could take as an implicit concession their statement that they were admitting with explanation rather than denying. And am I right, though, am I right in thinking that although that was the position Capital City took through its representative at the hearing, you don't have any objection other than the merits of the ALJ's ruling with the authority of the ALJ to respond to a plea of admit with explanation by saying, I'm going to find no violation. That's something that's within the ALJ's authority to do as long as the record supports and the analysis supports that conclusion.
That's this court's decision in CNN Produce, so I will recognize that precedent and won't take a contrary position here. But in any event, the evidence that was in the record established the violation.
But the ALJ has no authority, in your view, to, if there was no permit, if the evidence is that there's no permit and the violation under 21 DCMR is to have something in public space without a permit, the ALJ has no authority to waive that or excuse it or whatever, right?
That is correct, Your Honor. So the ALJ would have to find the violation. It would have to consider then the appropriate fine. And by establishing the violation, that would then permit DDOT to abate the violation if Capital City doesn't abate the violation itself. So we believe that the
Can I just make sure,
yeah.
I understand about fine, but imagine things had spun out differently than they did here, so that the ALJ had said, okay, I see that there's a violation, but and imagine the ALJ hadn't cut off testimony, so there was a full record of this, and the ALJ ended up saying, but it seems to me like the district is, you know, partly at fault for all of it. I'm not going to oppose a fine. You might have a dispute about whether that would be an abuse of discretion or, you know, an appropriate exercise of sanction authority. But are you saying there's whatever might have happened with the fine, the ALJ's sanction authority, having found a violation, does not extend to lifting a requirement of abatement? That just operates as a matter of law?
That is correct, Your Honor. So once the violation is established, and this is the type of violation for which abatement is required, then the ALJ can't excuse abatement. It may be that Capital City could request, well, we need some more time to abate it because it will require substantial modification of the building, or, you know, Capital City can certainly be heard, but as far as the time or manner of abatement, but the fact of abatement, it's still required regardless of what. You know.
That would be something that the ALJ here could have done? Actually get into the how or when the abatement has to take place?
To the extent that Capital City would want to raise it, I would acknowledge that Capital City would have the right to be heard by the ALJ.
No, I'm talking about what the ALJ's authority is. What's the scope of the ALJ's authority here? Because you seem to have said, well, the ALJ could have taken into account, assuming a fuller record that supported what they said, that they thought maybe it was going to be okay, that the ALJ could have reduced or maybe imposed no fine, which actually was what the ALJ, the only thing the ALJ said at the beginning with respect to admit with explanation, right?
Correct.
She seemed to say, if you give me an explanation, I might be able to do something about the fine, right? Mm-hmm. There's never any discussion about abatement at all. It's just that she then says, there's a violation, and then there's no violation. But I'm trying to understand what the scope of the ALJ's authority, given that it's OAH, you know, it's not really within the agency. It's you said that the ALJ did not have authority to say no abatement is required.
Assuming that a violation was found.
Right.
Yes.
No permit. Right. The evidence is that there was no permit.
Right, the evidence established that, we submit.
Right. I don't know whether the ALJ thought that the fact that the ramp was required by ADA and that there had been this back and forth, as she understood it, might somehow equate it to a permission, but you're saying that's just legally incorrect.
That's right, because as a matter of law, there needs to be a permit, which is a specific, there's a specific process for obtaining that permit. You have to apply. It's an online process. You have to pay a fee. A permit is a document that's displayed on the premises. It's certainly not something that an inspector would have authority to issue. For all these reasons, there's no permit. The violation is established. And for the ALJ to conclude to the contrary in language in the decision, saying that no violation of this regulation has taken place, and to excuse the fine because, quote, there is a complete defense to the charge, unquote, that is error. And so whether we would argue that the violation was established. Alternatively, if this court is not convinced, there would need to be a remand necessary in order for DDOT to have a fair opportunity to establish that violation.
So you would say that as a matter of law, the ALJ's conclusion that the ramp was approved by the Department of Transportation and a certificate of occupancy was issued is as a matter of law, incorrect. The ramp could only be approved. I assume she was relying on what she credited to be the verbal representations of Mr. White.
Perhaps. I mean, I'm not sure myself exactly what that reference is to. It may be, but in any event, even if it's the verbal assurance of the inspector, that is not a permit. As a matter of law, that is not a permit that would satisfy the regulation.
And neither would the certificate of occupancy, because that was for inside the building.
Right. A certificate of occupancy, again, is a different thing. That's DC Department of Consumer and Regulatory Affairs. Once the construction is complete, it authorizes a particular use of the building, but it is not an authorization to use public space. There's no contention that there's some authorization in there to build ramps on public space. It's just an entirely different creature. So again, that would be legal error by the ALJ.
It's an aspect of the ALJ. It seems like one way of looking at the ALJ's thinking was that the ALJ was groping towards concepts of estoppel. Would you agree that although it's very difficult to estop the government, sometimes it might be possible to estop the government from enforcing a permit requirement?
I do recognize the zoning cases, for example, where equitable estoppel has been considered and perhaps once or twice applied. I wouldn't concede that it would apply in this type of case because this is public space. Zoning involves the use of one's own property. This is public space. It's land held in the public trust for public use. It's a public sidewalk. And so just as, for example, adverse possession wouldn't apply to the government in that sort of situation, I would argue that equitable estoppel wouldn't apply either. In any event, it's a compelling public interest that would at least indicate that that doctrine should be extremely disfavored. And it has several different requirements, many of which are not met. This court couldn't sustain the ALJ's decision on equitable estoppel grounds because it was not specifically relied upon by the ALJ. Even if perhaps there's some language in there that might suggest an equitable estoppel concept, the ALJ did not mention equitable estoppel, didn't apply the test for equitable estoppel, didn't say it was actually could be applied at all for the reason I suggested.
I tend to agree with all of that and more in the sense that accepting the district's view of the process, the district didn't necessarily have a full chance to address the evidence that would be germane to whether estoppel could or could not lie.
Yes.
But I guess my question is more towards whether we should grant your primary relief, which is to essentially remand with instructions to find a violation and proceed to penalty, or whether instead we should say, look, there seems to be floating around a kind of a estoppel concept. Maybe that's what the ALJ was getting at least in part, but there are concerns about the process, and certainly that was never stated, and so maybe we should send the matter back for the ALJ to consider whether that is a procedurally and legally available avenue for relief.
Yeah, well, we would prefer the court not do that. We don't think that not only was it not addressed by the ALJ, it wasn't actually presented below as a theory. And again, there are specific requirements that would have to be established. Capital City did not attempt to go through those requirements and meet those requirements. So we would argue for a straight up reversal to establish establish that the violation was established, and so the ALJ can address the proper fine. That would be our position foremost.
Thank you.
So,
we'll give you a few minutes for rebuttals.
Thank you.
All right, Mr. Evans?
Good afternoon. May it please the court. Philip Evans on behalf of Respondent Capital City Construction. I think I've hit the range of scale of development today, from the biggest to the smallest. So I'll be brief. I think one of the important things to talk about in this record is the question about whether or not the judge prevented Mr. White from testifying. The record doesn't say that. She said, I have enough, and his response was okay. He did not say, I need to say more, I don't think this is appropriate. I disagree with Mr. Wurzel's testimony. That's the key, is Mr. Wurzel's testimony was the record before.
So even if we agree with you on that point that Mr. White wasn't prevented from testifying, we're left with whether or not the ALJ's conclusions were contrary to law.
And here's the law. The law in the District of Columbia, I generally agree with Mr. Schifla that public space is under the domain of the District Department of Transportation. Public space is East Street. So when you had construction here for any number of years and you couldn't go down East Street, that was by the District Department of Transportation.
Was a permit required to build a ramp on the sidewalk in front of the
Permission is generally required to
No,
occupy.
was a permit
I think that's where the
required from
distinction lies
DOT?
about whether, usually you get it through a permit. There is a process. But our position is you can also get permission by the agency, others. They're temporary and permanent nature. I think the facts here,
Permission to do what?
to occupy public space and to give the reasons.
Well,
You mean the say-so of the inspector?
The inspector is who is out there representing DDOT on a daily basis. The inspector is the one, when according to Mr. Wurzel,
So it is an estoppel.
what is an estoppel?
Is it it's an estoppel
I think the
theory.
facts here would support estoppel.
But your first argument is not as estoppel. You're saying that the word permit in the regulations can extend to an oral approval by a representative of the district.
I think the regulations are directed to call for a permit. But what I'd
Right,
say is,
in your position, I assume, but you're arguing that if I am if I'm building a building and I need a permit, but that's what the word is in the statute or the regulation, and I go to a government person whose job it is, let's say, so I'm not just taking a randomly selected employee, and I say, is it okay if I do this? And they say, sure. You think that that is a reasonable view about what the word permit means in statutes and regulations that require permits?
I've argued two different things here. So you're required to get permission of the agency. The agency has a process that they've
Well,
articulated 24
I'm not sure you're directly answering my question. Are you saying that at least sometimes, and here, that where a regulation requires a permit, that the word permit can be defined to include, leaving aside estoppel, it just is a permit that someone said orally it's okay to do it?
I think that can be fairly construed. There's times when permission by the
And
agency
do
acting
you have any case law that would support the idea that a statute or regulation that requires a permit, leaving aside again estoppel, where the failure to comply with the requirement could be, there might be a defense in estoppel, but that verbal approval can be treated as a permit within the meaning of a statute or regulation that requires that?
I can point to no direct authority out of this court.
I'm sorry?
I can point to no direct authority on that point out of this court.
Or out of any other court?
No, not that I looked at, because I generally went to the estoppel claim as well.
But the regulation says permit,
Yes,
and there is a permitting process.
there is.
Okay.
But I can also show you there are times in which there is temporary occupation of public space, in which is a matter of course for sophisticated developers like Capital City. The inspector gives instructions, do it this way. You normally would have gotten a construction permit, but you don't get it because you had a 2-day requirement to put a dump truck, do something.
that's a little problematic, don't you think? I mean, if a developer says, I'm gonna build a covered foyer to my building on the sidewalk, and the inspector says, sure, that's okay. I'm sure you could probably do that, or I'm sure you could do that. You're saying that's enough for a developer as sophisticated as your client to start building some unspecified thing
And what
of
the record reflects
unspecified
here,
dimensions? And the same thing with the ramp. I mean, maybe the inspector said, of course you can build a ramp. Many buildings have ramps to allow accessible entrance. That can't be enough in and of
actually,
itself.
what the record reflects here is the developer asked, proposed a different method of construction by increasing the slope of the sidewalk. The sidewalk is in public space. That's part of DDOT's germane. And the record reflects the inspector said, no, I want you to build a ramp. And I want you to build a ramp just like you did across the street a couple weeks ago. So if that doesn't suggest to a reasonable man that, okay.
Meaning specific dimensions were implied?
Well, they took care of the dimensions, because then the inspector got down on hands and knees with a tape measure with the developer and the contractor and measured these out. I mean, the facts aggregating enough, I think, to suggest that the reliance by my client on the approval by the agency was reasonable. And as far as estoppel goes, he then expended significant funds to build the ramps and the railings as part of this. Not discussed in all this is the acknowledgement by the ALJ, and not really contested here, is that accessibility ramps are required by federal law or some method of accessibility under the ADA, and that would be a controlling and element that would be required here, and that the equities favor my client over the district. I mean, if DDOT is now taking the position, their agent shouldn't have said what he did in the field, that's a DDOT problem. They can deal with that as a personnel matter. But my client dutifully relied upon instruction and direction of the inspector that he normally works with. DDOT in public space comes around infill projects like this all the time.
Well, you
Are
were
there-
just,
I'm sorry, are there any provisions in the permitting regulations that indicate exceptions or circumstances where a permit is not required?
The permitting process speaks to how you get a permit. It is what it is on its face, and there's nothing within the regulation that talks about, understandably, there's reluctant to allow rogue employees or rogue agents to the field. I get that. In the better course of action, one would have thought the agent would have said, you should do a ramp, and oh, by the way, you need a permit there.
you were characterizing the facts a particular way based on testimony that was presented to the ALJ. But leaving aside for a minute the dispute about whether the district had a fair opportunity to respond to that, the ALJ doesn't really find any of those facts, does it? The ALJ's order doesn't say, oh yeah, and I find that, Inspector X said the following to CCC employee Y, and here's exactly what was the understanding back and forth, and here's why the district has to be held to all that.
I would agree that the order is thin on recitation of the factual record in the transcript. But this court, I think, can construe the 20-page transcript along with the order to understand exactly what happened.
And can I ask
This
you,
is an ALJ.
the ALJ also says respondent built a handicapped ramp and had the permits to do so. How do you?
There may be some confusion between the two necessary permits here, or this type of project. To build on your private space, you need a construction permit supervised by DCRA. To invade public space, you need general permission from DDOT.
You need a permit, at least according to the word, you need, barring estoppel, which might be a defense, you need a permit. Now, maybe oral approval is a permit, if your view of the law is right, but you need a permit is what the regulation says, right?
Yes. So, I think, though, the ultimate issue, if the court is to remand, I think the only appropriate thing is to remand for a full restart. It's not appropriate just to interpose a violation and let it go on to some sort of remedies phase, because
Well,
it may not be a violation.
Didn't Capital City admit the violation?
And they admit with explanation. And as far as the ALJ process, believe that the court has the ability, as a matter of law, to determine because of the explanation there, in fact, is no violation.
Well, wait. That's what I don't understand. You admit the violation, which is, I constructed this without a permit, because that's what the regulation says, right?
Well, and again,
And the explanation is, well, and this is why I did it.
we have non-lawyers before the ALJ. They may not use buzzwords like estoppel or limit. What Mr. Wurzel admitted was, I built ramps in public space.
Right, as a factual matter,
As a
my
factual
ramp
matter. That was his
intruded,
explanation. He wasn't admitting to the violation of a lack of a permit because he didn't think he needed one. That's the key line that's
That
omitted.
seems to be how the ALJ took the admit with explanation, right?
Yes, and I think, if we're gonna go back, I think we get to go back, everybody gets to put on the evidence of all sides, because there are other parties to this conversation and communication that can establish the ultimate defense of Capital City.
But that all assumes that it is possible to get a permit by some means other than going through the permitting
That
process.
assumes you can get the proper approval to build in public space, yes, Your Honor.
I'm just quoting the language of the
I understand.
regulation. Okay, proper approval is your.
I think
yeah.
that distinction is important here, because there certainly are times in which approval is given to invade public space, and the agency does not regularly require a written permit per se, because it's a temporary. This one's not.
So you said, so the regulation in your answer to Chief Judge Blackburn-Rigsby is that there is nothing in the regulations itself that allows for exceptions or anything like that. So are we down to this question of interpreting the regulation, and who's going to do that? What does first obtaining a permit from the district mean?
And can you obtain a permit by implication as compared to express? I mean, I think the facts here have to go back to the ALJ for a full hearing. If the court determines they can't enforce the order as written, goes back so a full and complete defense can be presented.
Can I ask you a question that came up briefly with Mr. Schifferle, which is about the scope of the ALJ's authority with respect to sanction and whether abatement is a part of that. Is it part of the ALJ's function here to play any role in whether there is or is not abatement? And if so, A, do you think that is part of the ALJ's role? And if so, B, do you agree or disagree with the district's position, which is basically as a matter of law, the ALJ is supposed to order abatement but is required to if there's a violation? What's your position on those two topics?
I do believe the ALJ has flexibility to shape the appropriate remedy, whether they impose a fine. I think on the question of abatement, I think if the ALJ is to conclude this was installed in public space without permission or permit and this is per se a violation, I don't know if the ALJ would then have the discretion, having made that finding, to go outside of that. But I think he or she does have the authority to determine whether or not, in fact, a violation has occurred. I'll surrender the rest of my time to the court.
Much appreciated at this point in the oral arguments today. All right, Mr. Schifferle, we'll give you a few minutes for rebuttal.
Thank you, Your Honor. Quickly. Although this may seem to be a small case as compared to the first case this court had on its calendar, I do want to point out the significance.
No case is too small
And
for our full consideration.
I appreciate that, Your Honor. And I was going to point out that this is what would in effect amount to a permanent loss of public space. And it's a significant amount of public space. The handicap ramps are about 4.5 feet wide, and that takes up about half the width of the public sidewalk in this heavily traveled commercial corridor.
Can I ask, Mr. Schifferle, are there other cases that DOT is aware of where permission was granted without a permit to build on public space, either temporarily or permanently or preliminarily?
I'm not aware, but I mean, I don't feel well equipped to answer that question, Your Honor. But what I would say is it's one thing if a DDOT inspector says, okay, you can park that dump truck there for a couple hours while you do this, as opposed to what's involved in this case, as I said, a permanent occupation of a sizable amount of public space. And that is what we're here about. And that is, why it is important. And it's why when DDOT says you need a permit, not only can it enforce that violation, but also in terms of how we interpret what a permit is, DDOT would be entitled to deference in terms of what a permit is.
And what are we deferring to? The DDOT permitting regulation?
Well, the established practice and process, which, again, DDOT by statute is the agency that is authorized to enforce public space. And so it gets deference by virtue of that. And the practice, as I said, there is a process that DDOT has established.
Does that established process and practice ever include an inspector coming out to the site? Well, inspectors go out to the site of construction regularly, I would imagine, in the course of some projects. Does part of that process ever include the inspector initially saying, you're going to need a ramp here, and, you should get one that looks like this?
Well, I hesitate to answer that, and the reason is that this situation should have never arisen. This is a new building. It's the obligation of Capital City when they construct a new building that it be compliant with ADA standards for new construction. They did not do that. Through their own design and construction error, they built a building.
ADA standards would be different than the DDOT permitting requirements. In other words, if they had, Capital City had gone forward, looked at ABA ramp requirements and built a ramp, we'd still be in this position because they would not have gone through DOT's permitting process, even though their ramp might have complied with the ADA standards. Is that right?
That is correct, Your Honor. But my point is there would have been no reason for a ramp in the first place if this building had been properly constructed. Instead, they built it so that the ground level of the retail establishments was 4 inches above the proper public sidewalk, creating that 4-inch step that should never have happened in the first place. So I want to make that point clear. And also in terms of accessibility, again, to the extent they're relying upon the ADA, by narrowing a public sidewalk nearly in half in a busy commercial corridor affects accessibility as well. It's not a justification whatsoever under an estoppel theory or otherwise to rely upon what is their ADA obligations. And I would also point out, too, the question of who has authority to issue permits would again be an issue for DDOT in the first instance to at least get deference for who has authority to actually issue a permit.
So
It's
just
not
to
an
clarify,
inspector.
when you say their ADA, the developer's ADA requirements, you're saying that there could be some instances where the developer could meet their ADA ramp requirements without infringing on public space that wouldn't involve DDOT?
Right, Your Honor. It happens all the time because you would, in this case, what they should have done, which you would do with any new construction, is obviate the need for a ramp by building that level of the ground floor retail so that the entryway is level with the public sidewalk, in which case you don't need a ramp. That's what the 80 standards would provide, would be the way to meet those standards. Through their design and construction error, they did not do that, and they created this 4-inch step. And so it's their responsibility to comply with the ADA in the first instance. They didn't do that. They then can't find some alternative mechanism to meet their ADA obligations by appropriating public property for that purpose. So that was the point that I was making there. And in terms of the agent, it would be up to DDOT to say so, and Capital City is at least on constructive notice of who has authority to bind a government entity. And there's no contention here that that authority actually existed.
But there is this kind of argument we've been hearing that maybe the regulation itself could be read, permit, to mean something other than, going through the permitting process and getting a little piece of paper that you stick on your property or whatever you do with it, as opposed to what happened here, which is a permission from somebody in a position to know about this and who's, not just someone they picked up off the street. You say deference to the agency. Normally, it's certainly what we would do. It's charged with implementing this. It's regulation. But what would we look to other than the regulation, this regulation and the permitting process itself? What would we be deferring to? It's not like we have an opinion by somebody at DDOT. We have, we're not going to ask and defer to the ALJ at OAH, right? We don't do that.
Correct.
So to what would we be deferring?
So, I don't think it's disputed that there is a permit process.
Process, right.
Right, and this in no way complied with the process. There was no online application, no payment of a fee. A permit is an official document that is displayed on the premises. That's part of the regulations we cited in our motion/brief. So there's no contention that there was such an official document, which the regulations require. And again, it goes back to the authority point that an inspector does not have the authority to issue a permit. So therefore, whatever verbal authority they got, by definition, cannot be a permit. And so for all those reasons.
But just, those are all arguments that are made to us, and we can look at them and decide whether we're persuaded by them or not. Unless someone on behalf of DDOT has said, oh, and this is how we interpret them all, it's not so clear what we're deferring to. Are you arguing that as counsel for DDOT, the position you're taking in this brief is entitled to some kind of deference, or are you really just saying, look at the regulations and you don't need to defer to anybody? DDOT hasn't formally interpreted them either, but you'll read them and you'll realize that that's not what a permit is.
Well, that is part of my argument for deference, Your Honor, that this is DDOT's official position. It's been expressed in briefing before this court. This court has recognized deference in that situation, but I'm not relying exclusively on that. There is the established process, which Capital City acknowledges. They're a sophisticated developer. They follow that process all the time. There is the regulations that do discuss the fact that, you know, what a permit is. It's an official document displayed on the premises. For all these reasons, we would submit that it was established on this record that that the violation occurred. To the extent that there's any question about it, first of all, I would say Capital City had the chance to present their case. So to the extent they want to reopen it entirely, I would object to that. But to the extent that this court does have a question about whether the violation was established, there should be a remand so that DDOT has a fair opportunity to actually present its case and establish that violation so that abatement can occur. And that's what this case is about.
All right, thank you.
Thank you.
All right, we thank both parties for your briefs and arguments, and we stand adjourned at this time.